business before the court draw near, you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Today is May the 9th. Welcome to the Lawrence County Municipal Court. I'm Judge Capper. We have, the first thing we do is what we call review hearings for people who have been ordered to do things. And this is a review of whether you're making progress on that. So if you have a review hearing today, you'll be called with a group. Come up when your name is called. Anybody that's out in the lobby has a review needs to be in now. If you miss your hearing when it's called, you're going to go to the end of the docket. So, and if you don't get called and you think you should have been, go to the clerk's office and check in with them to make sure you're on the docket today. If you missed a hearing before, you're not automatically going to be on the docket today. You have to go tell them you're here and they'll put you on the docket. Clerk's office to the right as you leave the courtroom. Call the reviews.
Caleb Owens, Stephen Carmen, Deshaun Cooper, Christopher Hale, Kathy Knight, Daniel Lucas, Clarence Mahan, Michael Martin.
Caleb Owens.
Yes.
Case number 24610. Okay, you paid your fines. You were ordered to continue with treatment too.
And I actually have all that. I just hadn't got it printed out yet.
Where were you going?
Restoring Hope Recovery Care.
Oh, that's right. I have a report from them last fall when you were there. Okay. Are you completed or still doing treatment?
Well, they told me to do 6 months, so I done it.
You're finished?
Yes.
Okay, I need a letter from them saying you're finished. Can you get that?
I've got it actually on my phone. The lady that normally does it is out of town, but she emailed it to me.
Okay. Go see Mr. Major in the probation office and you can email it to him. If he's satisfied, your case will be completed. I'm going to give you a date just in case. If he says that's not sufficient, then you'll have to come back. If he says that's good enough, and he's going to put it in your file, then you don't have to come back.
Okay.
So let's make it about a month from now.
What date?
Okay, I'm picking out one now. June 16th. 9 o'clock. Go check in with Mr. Majors and email to him a copy of what you have.
All right.
He'll tell you what the address is now.
Right.
His office is to the left as you leave the court. Stephen Carmen, 22-2038. Stephen Carmen is not here. He hasn't finished. He hasn't done any of the community service he was ordered to do.
Your Honor, if I may, I have a note that he was supposed to have his community service finished by today.
Yeah. Yeah, it's been a while, so he should have had it done. He hasn't appeared, so he gets a warrant for not appearing. Deshaun Cooper, 24-21-41. This is on an OVI, and I'm showing.
That is recovery.
It's supposed to go to pathways.
That is, and that's Crescent Counseling.
Your Honor, he's turning in 30 hours of community service.
It's 28 hours. I have 2 more left. I was planning to go finish it today after I leave.
That's correct.
Okay.
And it is acceptable as manual.
All right. Are you living in Charleston now?
No, I go online with my therapist.
Okay. Because I thought were you living in Kentucky at one time?
Yeah, I still do.
Still are?
Yeah.
Okay.
I also enrolled in the DIP class. I was a little bit late to enroll, so I had to wait for the next one, and it's May 29th through June 1st.
Okay.
And I
Did you
have,
get that? And you get that completed, I'm gonna set you for June the 30th.
Okay,
You get that completed and filed, and your community service done, you don't have to come back. That's
Okay.
all you got left.
would I be able to get unlimited driving privileges, because I work full-time and my dad is in hospice right now?
I can't give you unlimited driving privileges. I can give you, this entry should have said, yeah, I can give you limited driving privileges. If you want unlimited, you'd have to place, if it was an alcohol related, let me see.
I have the Intoxilock in my car. I've had
Oh,
it.
okay.
I've
Then
had it
you
for
can
about
have-
3 months.
You can have unlimited,
Okay,
as long as you have that on your vehicle.
okay.
So do a new entry saying you have driving privileges through, let's see, when your suspension's up.
I think it was up April 17th or April 11th, but I can't get my license back until after I finish the dip class.
Okay, so I'll make it through the next review hearing, June 30th.
Okay, thank you.
So, all right, if you get it done, you don't have to be here, but your driving privileges are going to expire then, so you'll need to get reinstated by then. Okay. June 30th. Ready to get the next one? Okay. Christopher Hale, 2487. Okay, he's at our.
40.
Okay. You still have community service to do, so
Yes, sir.
get that finished.
I've been trying to come out on Saturdays. I work Monday through Thursday, but I have group on Fridays sometimes. And,
Saturdays work, so you have
Okay.
community service every Saturday, unless it's a holiday.
okay. Do you know how much community service I have left?
I'm showing 42 hours.
Oh, okay.
If you want, you can talk to Mr. Major about it.
That sounds about right. Cool.
$590 is what I'm showing you, still in the funds.
Yes.
Okay, your next hearing, this is an older case, so it's going to be sooner.
Is there any way it can be after the 6th?
Yeah.
Okay, I'm
Make it
going.
on the 9th, June 9th.
Okay, that works.
That's 1 month, exactly. June
Thank you.
9th, 9 a.m. is your next hearing. Go see the clerk, make your payment.
Yes, sir. Thank you.
You're welcome. Kathy Knight, 24-147. She is request.
Ms. Knight's completed our program. We've set her up with social services to help with her medical needs, prescriptions and stuff like that, just to provide extra care.
Okay.
But she's done well for her ability.
All right. Well, sounds like they want to continue to help you. Are they doing
Yeah.
things to help you? Okay, I'm not going to require you to do that, but I think it's a good idea. And you've completed everything I ordered you to do, so I'm not going to give you any more review hearings.
Okay, thank you.
Congratulations, you've completed.
All right.
Clarence Mayhem, 24-674 and 675 and 21-187. Okay, your community service now, you're paying on fines. Do you have a payment today?
I got 50 today.
50?
Yes.
All right. See the clerk to make that payment. And I'll set you for June 9th also. June 9th, 9 a.m.
Okay, thank you.
You're welcome. Michael Martin.
Sir.
22-163, 19-4006. He's at RRS. I've got a report from them. So it's sounds like we had an issue last month. Let's get a urine screen today and see where we are. Go to the probation office and get a urine screen.
Sir.
Come back after you do that.
Brandon Miller, Shane Ortiz, Logan Wright, Shaylin Roman, Otis Sexton, Ashley Webb, Holly Wingate.
Brandon Miller is 23184. Brandon Miller. Finished community service, is not paid off his fines, so there'll be a warrant for failure to appear today. Shane Ortiz, 25267. All right, do you have a report for me from Pathways?
I do. It should. I talked to my probation officer, and they printed it off. They should be giving it to you.
He did, Your Honor. We do have a report.
All right, well, when I get that, so just step back and I'll go through some of these other folks. Come back to you. Logan Wright, 24512. All right, I'll see. Have you done anything on your case for today?
What is it, sir?
Have you done anything on your case before?
Yes, sir. I paid on the fine online before I came in.
How much did you pay?
40.
And where are you living now?
In Ironton.
Okay, so you're close.
Yes, sir.
All right, your next hearing is going to be June the 9th. And all you have is fine, you don't have any community service. So get this done and we'll come to these hearings.
Yes, sir.
June 9th, 9 o'clock is your next hearing.
Yes, sir. Thank you.
You're welcome. All right, so Mr. Ortiz, I've got the report now. It's pretty lengthy, so let me review it. Okay, it's a good report. It's acceptable. Now, you've got community services, so
Your Honor, I submitted the community service hours in my last hearing. I was here.
okay. Has it been reviewed or?
I don't recall, Your Honor.
Okay. I don't have anything showing a credit for it.
If it's not updated, I've not received it.
It hasn't been updated. Okay.
Where'd you do your community service?
It was the Veterans Museum in Moorhead, Kentucky.
I don't remember seeing it, Your Honor.
Who did you submit it to?
You, Your Honor.
Okay, so it should be in the file. You submitted it at the last review hearing?
Yes, Your Honor.
Was it on letterhead?
Yes, Your Honor.
I'm not seeing anything in here on that.
I can call, Your Honor, and have them resubmit or email.
Your Honor, I'll speak to him and have him just make sure to get me a copy of it.
Yeah, I don't see, there's nothing in the file about community service that I can see, so you need to get another copy made of that and submit it. And you did make a payment yesterday, it looks like. Okay, are you working
Yes, Your Honor.
Mondays or Fridays for your review hearings, which is better for your schedule?
Fridays, Your Honor.
Okay. I'll set you for June 20th, that's a Friday. June 20th, 9 o'clock, give me to the court the report on your community service.
Thank you.
Pretty good.
Thank you, Your Honor.
You're welcome. Shaylin Roman, case number 221524. Has not appeared, hasn't done anything on the case, it'll be a bench warrant for failure to appear. Otis Sexton, 24770, 24539. All right, Mr. Sexton, do you have a payment on your funds today?
I just paid last night.
How much did you pay?
I'm not sure my wife paid it.
Okay, well, then I'm going to schedule you back in a week so you can see what was actually paid.
Okay.
May 16th will be your next hearing. $9. Ashley Webb,
Thank you.
24711, Ashley Webb. Well, she was supposed to get an assessment with ODP. She's done everything else, but I don't know if she got an assessment.
I haven't gotten a report from her. I can check on it though.
Do you need any identification information?
Yes.
It's Ashley, middle initial N, Webb, W-E-B-B,
And what's her date of birth?
117.
Yeah, I'll check on that.
Okay, we'll recall after you. Holly Wingate, 24704. She's at ODP.
So it is my understanding that Ms. Wingate has switched from OVP. due to, she said that she was having issues with getting her medications correctly through OBP, so she switched to, what's the name of it?
It's called Groups Recover Together. It's online. I can get a progress report for you.
Well, the last time you were here, I had a report from Huntington Hospitalist Group.
Yeah.
Not going there anymore?
No. I got a full-time job and I work Monday through Friday.
Okay, well, based on what I see in your history, I want you to do a urine screen today.
That's fine.
Okay, let's get a urine screen, then we'll decide what we're gonna do going forward. Okay, other than those recalls, we have 3. Do you have another one?
Your Honor, we had called Brandon Miller earlier, I know he said he was not there soon.
Okay, Brandon Miller is appearing by teleconference.
Y'all gotta step out, we got papers.
23-184. All right. Is Brandon Miller there?
Yes, I'm here.
Okay. You just owe fines, it looks like. I don't see you've done your community service, it looks like. Well, and you completed the driver intervention program, that's been done too. So, have you made a payment on your fine?
I made a $50 online payment this morning.
Okay. This is an older case, I'm going to set you pretty quick. So June the 9th, a month out, is the next hearing. Once you get this
June 9th, okay.
As long as you're making progress, I'll let you appear by teleconference.
Yes.
All right, June 9th is your next hearing, 9 a.m.
Okay, thank you.
You're welcome.
Recall Michael Martin. Michael Martin.
Okay, Mr. Martin did a urine screen and it's clean, good. Good screen today. And he's compliant with RRS. Is he available to do community service now? Because he still has some community service left to do.
He is working Monday through Friday, but the weekends are available, right?
Except for morning group, I can't be here early.
Oh, we have morning group,
On Saturday or?
Saturday, yeah, we only have one group Saturday, it's from 7:30 to 9:30. But yeah, I mean, we can start making something happen though. He has to get it done, he has to get it
He's
done.
got 3 more days of community service that needs to get done in some way. Okay. All right, good job. I'll schedule, these are older cases, so I'm going to schedule them for June 9th also. June 9th, 9 o'clock is your next hearing.
Yes, sir.
Okay, so that, other than the ones we're waiting on urine tests, that finish the reviews, we're going to start the arraignments. If you think you should have been called, sir, as I said before, go to the clerk's office and check in. We're going to start he can go now. I'm going to let him go. Go ahead. Okay, anyone that's got an arraignment, a new case needs to be in the courtroom now. When your name's called, come up to the table to your right, stand there. I'm going to go over the charges with you. The prosecutor decides the charges. I don't decide them. When I see them, it's the first time I've seen them. They may not be true, but you need to understand what you're charged with. You don't have to agree with it, but you need to understand it. You have a right to have an attorney appointed if you can't afford one. You have a right to remain silent. You don't have to say anything. If you choose to make statements, though, what we're all saying is being recorded. So if you admit something about your case, it could be used against you later. You have a right to have bail, to make the state prove any charge against you beyond a reasonable doubt. Those are the rights that all defendants have. If you decide to enter guilty or no contest, you're waiving those rights. You shouldn't do that. If you don't understand what's happening, if you're confused, if you want a lawyer, if you want a trial, or if you don't know what to do. Not guilty is always the safest plea to enter. Enter that plea when you're asked for a plea, if any of those things apply to you. Call the first case.
Hey, y'all have to keep it down out here, all right?
Well,
State of Ohio versus Robert Clark, case number TRC 25896, A, B, and C.
Sir, are you Robert James
Yes.
Clark?
Yes, sir.
All right, Mr. Clark, it's alleged that on May the 4th at 8:36 p.m. in Windsor Township, you were driving a vehicle while you were under the influence of either alcohol or drugs or a combination. Now, the state's test is saying that you took a breath test to test your alcohol level, and it's below what's called the per se level under Ohio law. The state's alleged you tested 0.76. The per se level is 0.8, so the state's not, just on this, not entitled to a presumption that you're impaired if your test score is below the per se level. Do you understand that?
No.
I know it's a lot. Okay, the state would actually have to show you were impaired. The test is not going to show it by itself. That's what I'm trying to tell you. So, and this is alleged to be your first offense. On a first offense, the maximum penalty is 6 months in jail, $1,075 fine, and a 3-year license suspension. The minimum penalty is 3 days in treatment, $375 fine, and a 6-month license suspension. You're also charged with failing to maintain a sure clear distance ahead, which usually means you ran into another vehicle or something. It's a minor misdemeanor, maximum penalty is $150 fine, and that you were not wearing your safety belt. That's a mandatory $30 fine if you're found guilty. So, based on your test score, I would recommend strongly that you enter a not guilty plea. Take my recommendation?
Yes, sir.
Okay, we'll enter a not guilty plea. Do you have the money to hire a lawyer?
Not really.
Do you have a job?
Yes, sir.
What do you do?
Flag for CJ Hughes.
CJ Hughes Construction?
Yes, sir.
Are you paid by the hour?
Yes, sir.
How much per hour?
$17.52 an hour.
How many hours a week are you working?
Anywhere between 30 to 52 hours.
Okay, do you have dependents? Do you have children you're supporting?
No, sir.
You're a single person?
Yes, sir.
Okay, well, I probably can't appoint a lawyer for you. So you're making about $35,000 a year gross, is that right?
Yes, sir.
Okay. Well, I can't appoint a lawyer. Let's get the prosecutor out here and see maybe he'll do something on it even without you having a lawyer because you're below the per se level. See what they want to do with this case. Can you show me the A case on the computer, please? No, I charge him more. Okay, this is Robert James Clark. He's 20 years of age. He's charged with the regular OVI under that statute with a test score of 0.76. It doesn't look like there's any other tests taken that I can see. But there was a wreck. Looks like there's a traffic crash report. So I don't know if you want to look at this and make him any kind of offer. He doesn't have a lawyer, and it doesn't sound like he wants to hire one. So,
well, I just looked at it this morning.
Okay.
And recognized the fact that it was below .08. Probably a reckless operation would be in order because of the crash.
well, he's underage.
Well, we could do that in OVUAC,
Yeah.
and that would be acceptable.
Okay, and I'm not trying to talk you into making a decision. You have the right to talk to a lawyer, but you're going to have to hire one. You make too much money for me to appoint a lawyer for. So you're charged with a regular OVI under the statute, but because you tested below the per se level, the state's willing to amend it to a lesser charge. Now, it's not reckless operation or anything like that. It's still potentially jailable offense. Under Ohio law, you're not supposed to drink alcohol until you're 21. And states allows you're 20. So there is a statute, subsection of the statute that says if you're operating a motor vehicle after consuming alcohol underage, It's a fourth degree misdemeanor. This is a first degree misdemeanor. The maximum penalty is 30 days in jail, $250 fine. Now here's the kicker. There's a mandatory 90-day license suspension if you're found guilty of that offense. So there's still a license suspension. So that's what they're offering you today. You don't have to take it. You can probably still get that if you get a lawyer, but you don't have to hire a lawyer. How do you want to proceed? Do you want to take some time to think about it? Do you want to do something today? How do you want to go forward?
Can I have some time to think about it, sir?
I'm sorry?
Some time to think about it.
Okay, I'm going to enter a not guilty plea for you. And how much time do you think you need to try to get a lawyer? Let me tell you what I've got available anyway, because it's going to be a little while before I would schedule it back. Probably the first date I would be available would be 2 weeks, so the 23rd or any time after the 23rd of May, I could schedule it for another hearing.
That's all right, sir.
The 23rd, that's 2 weeks.
Yes, sir.
Okay, your next hearing is going to be May 23rd for a pretrial at 10 o'clock. I'm going to let you sign a $1,000 signature bond. And what that means is as long as you show up, you have promised like an IOU. I owe $1,000 if I don't show up. As long as you show up, you don't have to pay anything. Just show up when you're supposed to.
All right, sir.
I'm going to put down will hire, and there's a form there for you to put your next hearing date on. Did you get that? May 23rd, 5:23, 10 a.m. So your license is not suspended because of this, because you're below the per se level. If you've been above it, you would have a license suspension.
What time was that?
10 o'clock.
All right, sir. Thank you.
You have any questions?
No, sir.
Okay, that's all. May 23rd, 10 o'clock is your next hearing.
All right, thank you.
You're welcome.
State of Ohio versus Cheyenne Meisner, case number TRD 143404, TRD 143120. Cheyenne Meisner or Misner.
Okay, all right. It says this person was arrested. Did they post a bond? I don't see a bond. Don't know why. There's been a warrant outstanding for a long time. So I don't know why it was on the docket. I'll pass it. So we find out if she posted a bond. Not in jail. We'll need to figure out if there was a bond posted. Not one in the file.
State of Ohio versus Curdy Allen, case number TRD 24268, A and B.
You're Kurt Allen?
Yes, sir.
Okay, you had a review hearing on May 2nd. On no operators and a speeding offense. You
Yes,
paid
sir.
your fine, you just have to do your community service.
Yeah. And my community service is done now, too. I just
Okay,
finished
you
that.
got some proof of that?
Yes, sir. I faxed it in. I emailed it in.
To who?
My probation officer.
To Mr. Major?
Yes, sir.
Okay, well, here's what I'm going to do. He's here, he's in his office. I'm going to give you another date. You go meet with him, and if he says you've got the proof in, then he'll mark your file completed, and you don't have to come back.
Yes, sir.
So, are you working, sir?
No, sir.
Okay, so it doesn't matter if it's Monday or Friday for your hearing.
Not at all.
I'm going to make it June 30th. So this is a new case. So if for some reason your community service isn't acceptable, you got to be here June 30th at 9 o'clock. If he says you're good, then you don't have to come. Go check in with him. He's in his office to the left as you leave the courtroom. Thank you. You're welcome.
I see the land is built on the screen.
Okay.
State of Ohio versus Richard Powell. Is that the?
No, it's Justin Laguerre.
Oh, I'm sorry.
I'm in charge now. We're looking for the file.
Case hasn't actually been called quite yet.
All right.
State of Ohio versus Justin N. Laguerre, case number CRB 24817.
All right, Judge Landefeld, you're on, man.
Thank you, and good morning. As you know, this is the matter of State of Ohio versus Justin Laguerre, CRB 24817. I'm Judge David Landefeld, retired judge sitting by assignment of the Ohio Supreme Court. I believe we're here today on pre-trial in this matter. Have the parties had, and gentlemen, you may sit, I don't.
We don't have chairs here. There's no chairs at this table right now.
Oh, I see, okay. Well, first of all, have we complied with Marcy's law?
As far as speaking with the victim about the matter, yes, Your Honor.
And is the victim present or waiting his appearance?
I don't know if the victim's present or not, but we've been in recent contact with the victim and are aware.
And the victim is aware of this hearing, is that also correct?
Yes, Your Honor.
Okay. I mean, I would like to just have to continue the matter if the alleged victim hasn't been advised of this hearing. Have there been discussions between the parties here?
There has been, Your Honor. There's been an offer made. Mr. Laguerre's not inclined toward that offer. We are attempting to locate some witnesses. I'm going to need to file a subpoena. What I would intend to do would be to subpoena that information to another pretrial. So I'd like to ask for another pretrial date so that I can fill that in as the date to use on the subpoena. So I would ask for maybe about 4 weeks out if we could. We'll waive time constraints to accommodate that, and I will ask for a date that's convenient for your appearance.
All right. Has discovery been complied with here?
Yes, the discovery provided by the state has been complied with. We're seeking to identify some witnesses that were not identified by the police officers. I'm just going to be trying to get some records from Kroger, which is where this happened.
Okay.
June 6th is about 4 weeks out, and I'm going to be here at the court that day, but I don't know if that's a day that works for the court, for Your Honor's schedule.
No, I'm afraid that doesn't. What about the 13th?
I'm actually already on the docket here that day too, so that day will work.
All right. Do I need to appear in person, or can we do this again by?
I think we can. I'm sorry.
No, go ahead.
I think we can do this by video because we'll either at that point have things figured out or we'll set a trial date.
And Your Honor, I've prepared a proposed time waiver, and I'll have Mr. Steyer sign. I guess we'll need to send that to you for your approval.
Yeah, this is a continuance entry with a time waiver on it. I've executed that, so we can get that. I think we get that to the clerk's office. They could probably get it to you, I would assume.
That's fine. They have my email. They can email it to me, and I'll sign that and return it. For the record, we are scheduling, and we're going to call this a final pretrial on Friday, June the 13th at 10 a.m.
Yes, Your Honor. Thank you.
All right. Okay, well, good luck to everybody, and I appreciate your participation here.
Thank you, Your Honor.
Thank you for joining us. All right, I'll get that speaker issued.
Your Honor, on Cheyenne Meisner, I did find out that she did appear at the clerk's office this morning and paid something. So they pulled the warrant. Apparently, they didn't show the court.
Right, Cheyenne Meisner will reissue a warrant because she came in, paid something on her fist, but didn't stick around for a review to be arraigned, so there will be a warrant issued again. The failure to appear.
State of Ohio recalls Holly Wingate, case number CRB 24704.
Okay, this was set for review today. Ms. Wingate, I ordered the urine screen, and she did, and it's good. So, all right, good job.
Your Honor, I have $30 to pay towards my fine. I spoke with my recovery coach, and she's going to tomorrow start every Saturday, bring me over here to do community service.
All right, very good. I'll set your, does it matter to you if it's Mondays or Fridays for your hearings?
It doesn't matter, Your Honor.
Okay. June 13th. At 9 o'clock is your next hearing.
All right, thank you, Your Honor.
Okay, thank you very much.
We're ready for pre-trials.
Okay, we're starting pre-trials.
State of Ohio versus Ashley M. Kane, case number CRA 24340 and CRB 24341.
It's Mr. DeWaters' case, and it's set for preliminary hearing and pre-trial.
It is, Your Honor. This is a case we discussed during pre-trial conference, sort of an unusual set of facts. But in any event, we've reached an agreement with the state to resolve this case. It's my understanding that the state's willing to dismiss the felony charge that's pending in return for a guilty plea to an amended charge in the misdemeanor case. It's my understanding the motion to amend is going to be to amend it to a disorderly conduct, a misdemeanor of the 4th degree. And the recommended sentence, of my understanding, is that the state's willing to recommend a 13-day jail sentence, giving Ms. Kane credit for the 13 days that she's already served, a fine and court costs, which she intends to pay today if you approve the agreement.
All right, the amendment will be to disorderly conduct 291711. Is disorderly conduct.
And Your Honor, this is with the knowledge and the consent of the victim in this matter.
All right. Ms. Kane, you have a right to make a statement if you want. You're not required to. Do you have anything you want to say before sentencing?
Ms. Kane did, Judge, indicate to me that she had intended to apologize to Mr. Moore. This was not in character for her, and she's frankly quite embarrassed to be here in front of you today. But Mr. Moore didn't want to have any interest in coming to court, so she would express, though, for the record, her apologies to the court and the state and Mr. Moore.
All right, I'll impose a $200 fine. Where the cost be paid, 13 days in jail, credit for 13 days served, 2 years of level 5 probation, distance should be paid, fine and court costs. Set your review hearing, November 7th of 25.
Your Honor, she's going to pay that today before she leaves, if that helps any.
Okay, so she won't have to appear then.
Thank you, Your Honor. Will that be all for Ms. Kane?
That's all.
I'll take her out to pay that.
Yes.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jeremy Bodmer, case number TRD 25376, A and B.
Calls Mr. Hill, apparently.
This is set for a pre-trial today?
It is, Judge. I owe the state a motion. I had a week-long jury trial last week, and it got off my radar. I apologize. We've had negotiations. I don't know if it's going to be resolved short of a motion hearing, but if we could set, and I'll told Mr. Hill I'll have that to him Monday, pre-trial on the motion hearing.
So you want a pre-trial on the motion?
You could, Judge, yes, and I should have had that filed already, but I got in that trial, and it just slipped my mind.
Okay. When, well, let me tell you what we're looking at.
Sure.
Probably not going to set anything until May 19th or after.
I'm here in May, Judge. I have the 23rd and 30th, then I have some June availability.
Okay, either one of those are available. Which one do you prefer?
If I find Monday, they give me enough for a pre-trial on Friday, Philip? The 23rd?
Sure.
The 23rd is fine, Judge.
May 23rd will be the next hearing. Will be a pre-trial on motion.
Thank you, Your Honor.
You're welcome.
And I'm going to ask for a time waiver.
Sure, well, it's not time waiver. Thank you, Judge.
State of Ohio versus Charlie Atkins, case number CRB 2588, ABC and D. Charlie Atkins.
There's a co-defendant on this, Tasha Atkins.
Let's call that also just the lawyer making that.
No, I don't.
Mr. Flyer.
That's your case. Tasha Atkins.
You see that checked in, Your Honor.
Yeah, that's case number 2587. This is 2588.
State of Ohio versus Tasha Ian Atkins, case number CRB 2587, A and B.
Here they are, Your Honor. You guys sit right. Your Honor, I don't think the speaker's working in the lobby. I don't know if it's off or if it's just not working, but
That's not even working.
apologies.
Roll. 5 days community service, 2 years probation. 30 suspend 27, 5 days community service, fine, 2 years probation. And forfeit dogs.
Introduced the offer to 30, suspend 27, still on 3 days in jail, fine, community service, 2 years probation. I don't think you guys have the dogs anymore. So they want to do forfeit the dogs, and that's a moot point. So they're 3 days in jail. I was trying to get him off jail entirely. He's not there. I don't know if he'll ever get there. But today the offer is basically 3 days in jail. If you guys decided to do that, we could arrange it so you go at different times.
I'd have to get time to work. I'm going to do my job.
Well, we can come back again, try to find some days that you could take a day. I mean, I assume, how many days a week do you work usually?
She calls me in like every day on schedule 5 days a week.
Well, we could get, if you could find a time when you have a holiday off or something like that. We could.
Send her on.
Okay. You can see the range of them. She might be able to make it. Are you okay with that? Well.
I mean, if it's all we have to do, it's all we have to do. I have never been able to
Come back, she can figure out when she can sign off. Unless it's set for trial.
There's a possibility. Okay, they just want to put it set for trial then. We can come back with that same situation, and if you have a time that you think you can get off work, we might consider that offer.
Either that or just arrange to, a month out to go to jail and arrange the day off. I mean,
I think we may need to set trial dates in there, Your Honor.
Yeah, set up for a bench trial.
When are we setting?
May 23rd is the first date that that's open for a trial.
I'd like to go a little further out than that if we could, because one of the issues here is there's an offer that involves jail time that would cause problems with employment. And it may be that if we come back, you might find out we've dealt with that. I don't think 2 weeks is long enough. The 13th, I said something earlier and that wasn't with you, but I don't.
13th of June?
13th of June. Does that work for you?
Yeah, that'll work.
Would that day work for the court?
Yes, June 13th for trial, and it'll be at noon.
and that will require a time limit in order to go that far out.
We'll execute that, Your Honor. Well, on my client's behalf.
Yes, we'll execute that too. Both cases are set for trial, noon, June 13th. Come on, will you? Okay.
I try to be here at 10.
State of Ohio versus Justin Robbins, case number CRB 25131. Your Honor, Special Prosecutor and the Attorney are available in Zoom.
All right, this is a case 25131 where Mr. Ashworth has been appointed as special prosecutor. He's appearing by teleconference. Mr. Holtz, the attorney for Justin Robbins, he's also appearing by teleconference.
Yeah, thank you, Your Honor. We have discussed this case. I've also discussed this issue with the victim. She's not going to be here today. She's agreed to this plan, and we've offered to push this case 90 days out, at which time, if there's no additional problems, then the state would nolly the charges and review.
Whatever you are, we'll wait time.
All right, thank you. Let's see, so we're looking at August. August the 8th.
Did we do the 11th or the 15th, Your Honor?
Yes.
Your Honor, I'm in trial this 2 weeks. If we push it to the last week of August, I think I'm going to be in the trial.
August 29th.
That works, Your Honor.
Does that work for you, Mr. Ashworth?
Thanks, Your Honor. I think absolutely sure it's part of the firm. That works, Your Honor.
Okay. August 29th. Case will be dismissed then if there's no further problems. And was there a request for costs to be paid?
I have the request, Your Honor.
Okay.
We're fine with that, Your Honor.
All right, August 29th, pre-trial, 10 o'clock.
Thank you.
You're welcome.
Yes, sir.
State of Ohio versus Michael Tilley Jr., case number CRB 24437.
Your Honor, could we call that case? We're waiting for a report to be faxed in. We don't have it yet.
Be recall after a report is received.
State of Ohio versus Emily A. Smith, case number CRB 23627.
Mr. Ashworth, do you have any more cases today?
We have one today.
Yes, Your Honor, I have a pretrial in Kessinger Mullins, and I have a pretrial in Amy DeMint.
Okay, we'll get those up next. All right, Emily Smith is Mr. Stratton's case, and I got a report from Mr. Kwan this morning from Southern Hope that she had left treatment, unfortunately. So, I'm assuming you don't have any contact, Mr. Stratton?
No.
All right. I hate to see it, but I'll go ahead and issue a warrant for her for leaving treatment and failing to appear today.
What day is she?
Okay.
4/12.
Thank you, Your Honor.
You're welcome.
Not special prosecutor.
State State of Ohio versus Tisha R. Kessinger Mullins, case number CRB 18318.
So, Your Honor, I don't expect Ms. Kessinger Mullins to be here. That's because yesterday I spent an inordinate amount of time speaking with her. She's a long distance over there, truck driver. She's in Missouri somewhere. She didn't get the message that there was going to be a hearing today. The charges in this case stem from a complaint that was filed in 2018 by a different special prosecutor and then remained relatively dormant for 6 or 7 years. I told Ms. Kessinger Mullins that she had a duty to be here today, and I could excuse her for it, but at the same time, I told her that I didn't object to her, she could get moved, and then I would tell her that I don't have a problem with it. She's actually going to agree to a plea of disorderly conduct. We just need to reset the hearing so that she can be here and finalize that. So it's up to the board, but that's all I have to report on her.
Do you have a date when both you and Ms. Kessinger Mullins can be available?
I think if you put it on that same date, Your Honor, that we just established, that would be too long. She told me that once you pick a date, as long as it's okay with me, that she'll do her best to be there. I told her that we'll most likely allow her to appear via teleconference if she was somewhere else on a job assignment. So I can communicate that information to her as well.
So you want the August 29th date?
Yeah, I think it's too long, Your Honor. Let's do something sooner, maybe in the next 2 or 3 weeks.
Okay. I'm here every Monday and Friday. What's your preference?
How about May the 30th?
That's fine. Okay, next hearing in this matter is going to be May 30th at 10 o'clock. And you can appear by teleconference.
Thank you, Your Honor. I'll communicate that to her.
Thank you.
State of Ohio versus Amy DeMint, case number CRB 24363, CRB 24525, CRB 24526.
Mr. Morford's the attorney for Mr. Dent, and Mr. Ashworth is special prosecutor.
Judge. Yes, we've been in contact. This case has been for a little while. I think Mr. Morford waited time the last time we were here. He's raised some alias defenses. We probably just need to set it for trial. Looks like it's not going to resolve. That's a trial. So I think I would just ask for a trial date.
All right, what's your availability? I'm setting, let's see, in terms of trials, pretty much any time in June I could set it.
That will trial in June. Actually, how about Friday the 13th? That sounds appropriate. Friday, June the 13th.
More.
We're in agreement, Judge.
Okay, I'll set it at noon. So all matters involving Mr. Dent will be set for trial then at noon, June 13th.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. That's all on that basis. Appreciate it.
State of Ohio versus Tamara Wilson, case number TRG 25834.
Mr. Shred's case set for pretrial for that.
Driving under suspension charge, Your Honor. Okay. Your Honor, she's got everything taken care of.
It's actually fictitious registration.
Yes, Your Honor, she's got everything taken care of.
Okay. She has papers if the court needs them, so I don't know if the state.
Approach, Your Honor.
Yes. There it is. All right, it's my understanding the state takes no position if the defendant is guilty plea to it.
Your Honor, plead guilty to the charge and just ask for.
All right, since it was her own plate that she put on, or it was off of another vehicle, I'll just give her a $30 fine, court cost. Can you pay that today, ma'am, or you need time to pay it?
I might need a little bit of time depending on how much it would be.
Okay, well, the court costs are 150, so.
180.
Total, 155 total.
She needs a little bit, Your Honor.
Okay, well, the way we have to do it now is I'll put her on probation, level 5, with a review hearing date. Used to be, I could just give you a time to pay. If you didn't pay it, I could send it to B&B and they suspend you. They won't do that anymore. Guess I shouldn't let that slip out. If you don't pay your tickets, they don't really care. They're not going to suspend you anymore. If you don't show up for a review hearing, then I can issue a warrant for you. I can still do that. So I have to set a review hearing. So it'll be November the 7th. You got till then to pay, or if you don't pay by then, you got to show up for a review hearing. If you don't show up, you get a warrant, and that's worse than getting a suspension. So go see Mr. Major in the probation office. Just pay it before November 7th, and you're good.
Okay.
That's right. You're good.
Thank
To
you.
the left as you leave the courtroom, go check in with probation.
Okay.
I took off like this one that day.
Oh, okay. I'll pack it up there. Thank you.
State of Ohio versus Vicky Scarberry, case number TRC 24-1272, A and B.
This is Mr. Smith's case. He's supposed to be finishing their VP. Yes.
So Vicki did complete OVP. She had to be at Renaissance this morning to be able to admit to their program. But she did taper completely off of her methadone, is now on Suboxone.
Okay, she's at the Renaissance Center in Huntington?
Yes, through Prestera.
Okay. All right, she had to be there this morning about 10 a.m.
Yes.
So I'll excuse her not being here today because of that. So you just want to continue it?
Yeah, we'll just set another date, Your Honor, so we can see how she's doing there.
Yeah. Can you get contact information for her?
Yes, and I'll pass the court date along to them as well to make sure that she's here.
It looks like, from what I see in the letter, that they've signed a release
Yeah.
to permit communication, so we can get records.
23rd of May or after, what's your preference?
23rd is fine, Your Honor.
May 23rd will be the next hearing.
Okay, thank you, Your Honor.
And it'll be set, actually, it should be on the sentencing docket. 10 o'clock on the 23rd.
Thank you.
State of Ohio versus McCallan Wells, case number CRB 24657, A and B.
Also, Mr. Smith's case set for sentencing. good report, but it sounds like there's still things being worked on.
I believe she still has a,
CPS case, yes.
yeah, children's services case, so.
Yeah, a court date for that, when you go back to court.
June 1st.
Okay, so I would say come back after that.
That's fine, Your Honor.
Either the 6th or the 9th are good. What's your schedule?
I'm not available the 9th, I am available the 6th.
Okay, June 6th will be the next.
Thank you, Your Honor.
You're welcome. On the sentencing docket.
State of Ohio versus Alexis Destiny Smith, case number TRD 193668A and B.
It's Mr. Morford's case. Need Mr. Morford. Intercom apparently not working.
My approach, Your Honor.
Yes.
Your Honor, I was just informed that Mr. Morford has left.
Yeah, let's see if we can get him on the phone.
Hi, this is Butch Morford. You've reached my cell phone.
All right, ma'am, just have a seat. We'll try to get it hold of.
We have a report, Your Honor.
Well, I can't proceed without a lawyer.
I understand.
So let's try to get hold of Mr. Morford and see if we can. He couldn't be very far away. He just left. We'll recall him.
State of Ohio versus Mark Daniels, case number TRC 241469, A, B, and C, TRC 192674.
Wait, these are my cases. Your Honor, I think the state is seeking more time on this one. There's some further investigation that they want to do. We're agreeable to that and would waive time constraints for the purpose of a continuance. But I would leave it to Mr. Hill how long he thinks he needs to get the information he's looking for.
A couple weeks should be enough.
So I'm here the 23rd, which is exactly 2 weeks. I'm here the 30th. I'm here the 6th.
May 23rd.
Thank you.
May 23rd will be the next hearing, 10 o'clock.
State of Ohio versus Richard Powell, case number CRB 25193.
We need to approach on this one, Your Honor.
Okay.
The author just give him a little bit up here.
Mr. Steyer's case set for pretrial. Richard Powell.
I'm gonna ask her to be allowed to sit while,
Sure.
back here while we talk. I'm sorry. You can sit on that if you want to, you can sit on the chair, either way, whichever's easier for you.
All right, the state's going to acknowledge the terms here.
Okay. The case is dismissed. Yeah, it's dismissed, it's finished, you're free to go. Well, what's for you now? Sure. I'm gonna get the swing over for you here. Thank you. Yes.
State of Ohio versus Kayla Harris, case number TRD 211692, CRB 21209.
Your Honor, we've got a couple different issues pending here. One, I think, is a still pending, very old driving under suspension. Ms. Harris is working to get her license back. She went and took what she thought was going to be, was it the driving test or the written test?
It was the written test.
She went and took what she thought was the written test, and she had to pay to take it, which I've never heard of this before, but they said, well, that was a practice test, you got to take the real one, but you passed. So she has passed the practice test. We think she can get the written test knocked out, and then she got to get her license back. I realize this is an old case, but also think we're seeing real progress on it, so I think it's worth letting it go on. The other matter is post-conviction, there's some fines that are owed and or court costs. I don't think there's any community service. I'm looking at the little thing, so she's gonna have to make some payments on that, or I don't know if there's anything that can be worked off on her case at this point. That may be a possibility.
Because there hasn't been anything paid. She can work her
Right.
bonds off, for sure.
So I can't do community
You
service?
can do some
I
community
can?
service to
Okay.
work some of that off.
All right.
So what I'm gonna do is ask for some more time on this, and
Well, let's go into June to give her some time to get some of that done. And of course, pretty wide open in June.
June 6th is about a month out. That seems like a reasonable time to come back and take stock.
Let's go a little further.
Okay, that'd be fine, Your Honor. I'm unavailable on the 20th, but I'm available on the 13th and the 27th.
Let's do the 13th. Next hearing, June 13th, 10 o'clock. For pre-trials.
Thank you, Your Honor.
State of Ohio versus Kevin Hay, case number CRB 22427.
Kevin Hay is Mr. Tyler's case, it's set for pre-trial.
Your Honor, if I may, she has done community service. I'll have to look to see how much. I believe it's, she had 5 days ordered before sentencing. I think she's done 5 days.
Yeah.
We're down on this case to some restitution that needs to be paid. Ms. Hay hasn't been able to do that. She's not working at the moment, and she has a consultation for possible open heart surgery on the 5th, is it 15th of June?
15th.
On June.
Actually, it's this month.
Oh, 15th of May, okay. we're not quite there yet. So on May 15th, she's going to go to Morgantown, be, I guess, evaluated, and they're going to determine whether and when the surgery will be done. Once we have that information, we might have a better idea when she'll be back able to work. This came up after Ms. Hay. This was an incident that allegedly happened prior to Ms. Hay's coming through here and doing a long period of time reporting in, doing cases with something that eventually got dismissed. She's continuing her treatment, and it looks like we're still seeing compliance. So I think we'd want to come back after the 15th, probably not too long after, so that we can hopefully find out when the surgery is going to be scheduled, if that's going to happen, and then plan accordingly going forward. So I'd ask.
The 19th works.
The 19th is probably a good day. That should give her time to get back. So the 16th might be a little too quick to get back from Morgantown, but the 19th sounds like a good day.
All right, next hearing will be May 19th for pretrial, 10 o'clock.
I have a question, if I may. We're talking about the criminal mischief case?
Yeah, that's what's currently pending.
All right, so what we wanted her to do, and of course this treatment is also a good thing, but the community service.
She's done that.
Okay, and then there was going to be restitution, but I realized that she's
not in a position to pay that right now.
Yeah.
How much was the restitution?
$120.
May 19th, next hearing, 10 o'clock.
Thank you.
Thank you. Good luck.
Thank you.
State of Ohio recalls Michael Kelly Jr.
May I have the report now?
Yes, Your Honor. Report from Pat. It was back there. It was just in, I must have overlooked it when I looked in the box, so.
This was an assault. I'll say my report. I think this was a relative, wasn't it?
Yes, and we were very interested in seeing Mr. Tilley get through his treatment and do well. So I haven't seen the report from today. Very recent. Well, it doesn't look like he's been there for a long time. Yeah, but I mean, the last one was in like February.
So you continue together, or?
Yeah. I have been up here in Ironton until my divorce was getting filed. Now I will be going back to Jackson so I could start going there physically again. I've been trying to call in, but every time I call in, she's either not there or on lunch or something like that.
And you're living in Ironton now?
I was currently, now I'm starting to move back to Jackson, sir.
Okay, because there's a path right here, just through.
Well, I was in the middle of a divorce and trying to figure everything out, didn't know where I was going.
What's the state's preference here?
We'd like to see him reestablish his connection to PATH.
Yeah, we probably need to get more sessions with Pat. So we'll do that, Your Honor.
June 9th, month out?
That's a bad date, Your Honor.
16th?
Yes, 16th.
June 16th, the next hearing.
16th.
State of Ohio recalls Ashley Nicole Webb. It's number CRB 2477.
Ashley did not complete her assessment, Your Honor.
Yeah, I think she left too. Ashley Webb, she was here earlier.
I don't know, I haven't seen her.
I haven't seen it.
Oh, okay, maybe, I was just checking to see if she was complete. All right, she was ordered to do that. She hasn't, she didn't appear today, so it'll be a bench warrant for failure to appear.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Alexis Destiny Smith. Your Honor, Mr. Winford is here. He was talking with her. I'm not sure where he is now. TRC 193668.
You're up. You're just called you.
Mr. Morgan, have you seen the report from Hometown Recovery?
No, Your Honor, I have not. I apologize, I didn't know she was here, Judge.
Well, it was an add-on. She came in on her own asking to change providers.
When I left, I never went home. I went straight from there back to that.
Well, here it says you were not behaving.
You need to talk to her about that, then?
No, Judge, if you give me about 15 seconds, I think I can get through it with her. They're sick, left, and they were being disrupted.
Because my daughter was in the house being life-flighted to Children's Hospital. I wasn't disrupting, I was seeing a second.
Well, that's what that says. You weren't compliant? Judge, she's here asking you to approve her transfer and treatment to Southern Hope. I believe she started there inpatient on Wednesday.
What's her response to the report from Hometown Recovery?
She says that she wasn't disruptive, but she was going through a difficult time. Her grandfather was ill during COVID.
My daughter
And
was being life-flighted the
her
other day. That's
daughter
what the group thing.
was being life-flighted to Columbus.
Okay, we'll have an evidentiary hearing at the conclusion of court today. In the meantime, I'm remaining her in custody until we have a hearing.
State of Ohio versus Nicholas Byard, case number CRA 25269, CRA 25270, in holding.
This is Mr. Stratton's case.
Your Honor, is he in holding?
Yeah.
I'm not sure why he's in custody.
Well, he has a Rule 4 hearing too, so I'm reining on that.
Okay. Because he's got a good report last time.
Do you want to talk to him about it first?
I didn't realize he was on the docket. You're on the code.
Well, since I think I arraigned him by teleconference previously, but there's been some warrants come up to other courts. So I'll let you take the court's
Yes,
files
yes.
if you want to talk to him.
Yeah.
So Washington County and Franklin County, I think.
State of Ohio versus Michael Brown, case number CRA 25.
This Steyer's case.
Your Honor, this is an F5 that's pending. Spoke earlier to Mr. Hill, I'm not certain whether their intention is to keep this matter in the lower court or to take it on. I don't, have you guys had any contact with the victim or any thoughts from the victim on this at this point?
Yeah, our most recent contact with her, we have spoken with her. So the question is, he was at Brighter Days previously?
He was, yes.
And he's in jail today, so I'm assuming something's happened there.
According to my record, he failed to appear for a hearing on January 31st for a preliminary hearing. Warrant got issued from this court, then he got arrested. So this is arraignment.
Well, so what we would like to do, Your Honor, is have this set for a preliminary hearing at the next available time, and then we'll try to have a victim here, and we'll determine how we want to proceed from there.
I'm available Monday, Your Honor.
Can you get your people here by then?
We will try our best.
Okay, I'll set it for, that's the 12th, I believe. May 12th for preliminary hearing. And now he has a $2,000 cash for surety bond.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Andrew Curry, case number CRA 23-464 A, B, and C, CRB 23-463.
I'll wait for where he would add on.
CRB 23-291, CRB 23-61, CRB 22-351.
Well, actually, I guess his case has been completed, so I don't know if his case is completed on the 17th. Of March.
That's not what I'm showing. Looks like there was a case, a hearing set for April 21st.
I think that was a review hearing.
Okay, yeah.
So,
That could be. And that he didn't appear for the review.
Right.
All right, Mr. Curry, the allegation is you failed to appear for a review hearing on your cases April 21st. Do you admit or deny that? Okay, I'll take that as a not guilty since you're not sure. I'll reappoint you, Mr. Steyer. Let you talk with him, and then we'll recall it after you do so. Here's the court's files, and then you're going to have your files today. You're welcome.
State of Ohio versus James DeMint, case number CRA 24-786, CRB 24-787 A and B, CRB 24-635, CRB 24-290, CRB 23-1859 A and B.
Skylar Smith's cases.
I think he got picked up. He came here.
He turns off.
These have been set for hearing on May 2nd. Mr. Dement did not appear then. I think he appeared Monday, and his bond was revoked then. He took some tests that failed. There was also a report that he had not been compliant with treatment.
Yes, Your Honor, it's my understanding that you would be willing to take him back if that was a possibility. If that's a route we could go, I don't know if that's something we can do or not.
Well, what he has a felony pending. What's the state's position?
Keep it
I'm
here.
just looking at how many times we've been through this, and as much as we all want to help him, and understanding that the road he's on is not the easiest either, but still, we've extended a lot of consideration to him. On the other hand, we also have misdemeanor charges here that we also take seriously, and if we separated them and had felony charges in common police court, misdemeanor charges here, it might unnecessarily complicate things. Our suggestion would be today is to try to come up with a way to wrap up everything such that he could plead guilty to everything here and receive a substantial jail time penalty, and then from there decide how much time he needed to do in jail, and maybe if they take him back to treatment at some point, then at that point at least we've got a known amount of punishment that he's subject to. So if that's not repugnant to the court, that's the direction we'd rather go.
And what's your suggestion with regard to the pending felony? Would it just remain pending, or would it be dismissed, and how would you go forward?
Well, it's the failure to comply. I don't know if there's another one. Is there also possession? Yeah, there's a possession.
I only see one charge, 24-786.
How about also 24-290 possession? That was the
Yes,
very first time.
there is a 24-290 also.
So if we made both of those misdemeanors, and then the rest of them are misdemeanors, and if you pled guilty to all of them, that takes the felonies off the table. We don't have to worry about ever going to the grand jury on these. But we would recommend 2 6-month sentences consecutive for a year. And then if they want to take him back to treatment, I think it would be appropriate for the court to maybe determine if he needed to do a little bit of jail time to do a little meditating before he goes back. That would be our suggestion.
Wish to counsel with Mr. Dement about the state's offer, Mr. Dement?
Yes, Your Honor, and I think 6 days in county jails.
I'm sorry?
I said 6 days in county jail is pretty bad. A full year in the county jail, I don't know.
Well, I'm saying that a good portion of that would be suspended, but my point is that
Serve some time before he goes back to treatment.
yeah, let him think about how much better that is than going to treatment than either being in jail or being on the run. I think being in treatment's the better alternative of all three of those.
All right.
Well, he's done very well in treatment at times, but
Yes.
he can never, yet, has never made it long term.
Okay. So that's a better understanding. So I thought he was just asking for the full 365 days of
I'll
jail.
let you discuss it with Mr. Dement, then we'll recall.
Okay, thank you.
Patient service supervisor. But if he's felon,
Your Honor, State of Ohio versus James Elliott, he's here at the court, case number TRD 25916. Your Honor, he's been waiting here since 9 o'clock this morning, and we've all was late getting the ticket to us.
All right, sir, you're James Levi Elliott
Yes, sir.
from Waterloo.
Yes, sir.
Well, the good news is, I don't know if the state's correct, but they charged you with not having a license.
Yes, sir. That is correct.
And they're saying you overturned, went off the road, swerved, missed a deer, overturned.
Yes, sir.
They gave you a citation for driving without a license and failure to control your vehicle. So here's Here's the good news. The bad news is you've been here since 9 o'clock and you're just now getting the case called. That's not such a big deal, but the good news is you got cited to the wrong court. So still need to make that call, I guess. We have a criminal court, criminal traffic court, where cases that have possible jail sentences come. That's this court today. You're not supposed to be here. You're supposed to be in the traffic court. So what I'm going to do, it's a technicality. So a lot of times people get mad when courts dismiss cases for other people because of technicalities, but when it's for you, you should be happy about it, right?
Yes, sir.
It's liberal judges. They cited you to the wrong court, so they're going to have to learn. We got some new troopers. They're still learning. Everybody makes mistakes, so I'm going to dismiss your case because you're in the wrong court. It doesn't mean that you have a license now. It doesn't mean you should be driving. If you want to drive, go get your driver's license. You understand?
Yes, sir.
If you get stopped leaving the court and they cite you to the right court, you'll still have to answer for that, okay?
Yes,
The case is dismissed. You're free to go because you were cited in the wrong court.
Yes, sir, thank you.
You're welcome.
State of Ohio versus Sean Foggin, case number CRA 25268.
Sir, are you Sean Foggin? Yes, sir. Mr. Foggin, this is an arraignment for you. You have a right to remain silent. You don't have to say anything. But what you say here today is all being recorded. It's on the record. So be careful about what you say because it can be used against you later. You have a right to have an attorney, to have one appointed if you can't afford one, right to have bond, and to make the state prove any charge against you beyond a reasonable doubt. You understand those things? The allegation against you is that there's a warrant for you out of West Virginia from the State of West Virginia Division of Corrections and Rehabilitation. Warrant of arrest. I've got it right here in my hand. And it says that the warrant was issued because of a conviction in the Circuit Court of Raleigh County, West Virginia, and that you have some parole violation charges pending against you in West Virginia. So they want you returned to West Virginia on these charges, or they want Sean Floyd Foggin, if you're that person. So this is, you probably heard of an extradition treaty, or extradition hearing. This is what this is about. This is extradition. You have a right to have a hearing for me to decide, do they really have a good warrant on you, and should I make you go to that jurisdiction? It won't be for me to decide whether you violated your parole or not. They're going to decide that. The whole issue is whether I should make you go to West Virginia. You can have a lawyer represent you in that hearing, and I can appoint one for you if you can't afford one. You can waive extradition, and that means I agree, I'm the person they want. I'll go over there and face what they have for me. Do you want to have an extradition hearing here? Do you want to waive extradition and agree to go to West Virginia? Okay. If you want to waive extradition, then there's a waiver form you need to look at over and sign where I place the X. Okay. I'm going to, since it is on a parole violation, I'm going to hold you without bond. I'm going to order West Virginia to pick you up, and they may not be able to get it done by then. If they can't, then I may give them more time if they ask for it. I'm going to give them a week. So that would be the 16th. So they need to be notified he's available to be picked up. Before May 16th at 8 a.m. So if you're still in the jail next Friday at 8 a.m., I'm going to see you back, probably on teleconference, to decide what to do then. If they've asked for more time, I may give it to them. If they have a reasonable request of why they couldn't get here. So he's on my docket for May 16th at 10 a.m. Do you have any questions, Mr. Fallon? Okay, that's all.
State of Ohio versus Stephen E. Hall. Case number CRA 19399, TRC 191406, A, B, and C. TRC 0769, A and B.
Stephen Hall. In the back. Okay. Sir, you're Stephen Hall? I am. It's alleged there's a warrant issued for you for not appearing for review hearings back in, well, one was from May of 13, and you should have got arrested. You got a citation from the OSP back in 19. Somehow they let you go. You should have been arrested then, in custody, but you weren't, looks like. The prior failure to appear for review hearing was on an OBI, and then you got an OBI from 2019 and a felony that is still pending. So let's go over those. Let me explain your rights to you, which you've heard this many times. The Miranda warnings, you watch any criminal shows. You have a right to remain silent. You don't have to say anything. You do say things, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove any charge beyond a reasonable doubt. You know, understand those rights? Okay, the charges from 2019, the most serious one, the felony, and you probably don't have a copy of it. Take the staple out. There's the identity fraud charge. It alleges that on May the 16th of 2019 in Fayette Township, without the consent of another person, you used their personal identification information with the intent to represent yourself as that person. That's identity fraud. It's a felony 5. Maximum penalty is a year in jail, $2,500 fine. Okay, there's a copy of your citation on the traffic charge. And that case number is TRC 191406, A, B, and C. The A case alleges May 16, 2019 at 2:36 p.m. Fayette Township, you were operating a vehicle under the influence of alcohol or drugs, and that you refused to take any tests. So the charge is a first offense, maximum penalty, 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. You're also charged with failure to control your vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. And distracted driving, that's a minor misdemeanor. Maximum penalty is $150 fine. So those are the two charges. Do you understand those two current charges that are unresolved? Do you have the money to hire a lawyer?
I don't, and I'd like to handle this very closely.
So Well, you've got a felony and you can't plead to a felony at the initial appearance, so I'm going to appoint a lawyer for it if you qualify. Are you working? You have no income? All right, Mr. Smith, I'll appoint you.
Yes, sir.
To both matters. State's position on bond.
The state would request a $5,000 cash or surety bond. But also the state, if Mr. Smith wants to talk to his client, we might be able to come up with something to resolve this today.
Okay.
I don't have a copy of the actual ticket. I've got everything but the actual.
It's in the file and there's a crash, so it's pretty thick. There was a crash.
I've got everything except just the, is it a first offense?
Yes, but he had a prior, I don't know why, because he had a prior, well, maybe it was outside the look back period. He had a prior in 07, according to the record I have. This was 19, so.
And it's a refusal?
I believe, yes.
Well, if Mr. Smith wants to talk with me about how we might resolve this, we can come up with something.
Okay. I'm going to set it then, are you available the 16th?
Yes, sir.
Next hearing at this point is May 16th, unless we do something later today. May 16th will be the pretrial on both cases. Bond for both is $5,000. We'll take care of both files.
And I will be for sure.
$5,000 cash for sure. You want the court's?
State of Ohio versus Gary Kazee, case number CRA 25-250-30.
For service. I don't think there's a state one.
No.
Sir, you're Gary Kazee? Yes, sir. Mr. Kazee, I'm Judge Capper. This is your arraignment. You have a right to remain silent. You don't have to say anything. If you choose to make statements, what you're saying is being recorded. It's on the record. It could be used against you if you did something. You have a right to have an attorney. You can have one appointed. If you can't afford one, you meet the criteria for getting court-appointed lawyer. You have a right to bail and make the state prove this charge beyond a reasonable doubt. You understand those things?
Yes.
The charge against you is domestic violence with priors. State's alleging that on April the 15th of this year in Union Township, you knowingly caused or tried to cause physical harm to Emily Rose Markham, and that she is either a member of your family or lives in your household, and that you've had a prior conviction for domestic violence. So that makes this a felony of the 4th degree. Maximum penalty, 18 months in jail, $5,000 fine. Do you understand the charge?
Yes.
Do you have the money? Well, since it's a misdemeanor, I ask you for a plea. How do you wish to plead? Well, it should be I'm sorry. It's not a misdemeanor. Somebody wrote CRB, which indicates misdemeanor. It should be CRA case number. So it is a felony. I can't ask you for a plea at your first hearing. Do you have the money to hire a lawyer?
No.
Are you working?
No.
All right, I'll appoint Mr. Steyer to represent you. Is the private drive 135, you correct?
Yes.
What's the state's position of law?
Well, Your Honor, I have a question, and that has to do with whether there's already a domestic violence of the felony level pending. I don't have a case number for it, but I've got a date of December 4th of last year when he was last before the court.
Out of this court or another court?
in this court.
Well, we can,
That case was nollied on 12/23/24.
It may have, okay. I don't know if that went to the grand jury or not. Does it say, Dorothy?
It was nollied outright, so there's no mention of grand jury on that one.
Okay. So we'd ask for a $5,000 cash surety bond.
I'll set that for now. You talk with him, and you want reconsider, we'll do it. 5,000 cash surety. Do you have a place to stay other than with Emily Markham?
She don't live with me.
Okay, well, then that means yes, you got a place to stay other than with her.
So the home, here's your address, 19 Private Drive.
Yes.
So she doesn't live in that address?
Yes, and I don't have any other family or any other.
I guess it could be a different.
I checked on the Common Pleas Court website, and there was nothing listed for him, even a downloader.
Okay, this is Keesee.
And that's what I thought you said.
Okay, oh, well, the other one was Kazee.
Okay, that's what you're saying. Thank you.
All right, I'm gonna let your lawyer talk to you. Should we go ahead and set it? I didn't set a date, no. How long have you been in custody, sir?
We did do a protection.
We need one here.
He's been in since last night.
Next Friday, are you available the 16th?
I believe I am, but it's certain that.
We're asking
I am available, Your Honor.
protection orders.
Okay, I'll order a protection order to stay away from Emily Markham. Next hearing is May 16th for preliminary. If you want to argue about bond, we'll do that later after you talk to the lawyer.
State of Ohio versus James L. Griggs, case number CRB 25254, A, B, and C. This case.
This is Mr. Smith's case for pretrial, James Griggs.
Yeah, I believe we have a resolution. Just I called earlier down to the jail and spoke to him on that.
Okay.
The state has made an offer this morning, 60 days, suspend 50, he's been in jail how long now? 10 days. 10 days. Could be a fine of the court, probation of the court, 30 hours community service. I asked him, this is, well, there's copy of that, so I don't think it's a restitution, I don't know if the state has verified that. It was an attempt to steal a Catholic murder, which was not accomplished.
So he's in pleas as to all charges?
Yes, sir. And we have the sentence we want to confirm.
Okay, there's a pretty, do you have a report on this? I mean, I've got an affidavit, it's pretty lengthy, I don't know if there's
Well, the report's the same thing. And basically, some people found Mr. Griggs under their vehicle beginning to take the catalytic converter, I think is the gist of it. And so all these charges arise from that incident.
Okay, before I sentence, and he's been in jail though since for a while, right?
Hey, at least 10 days.
Is there any substance use issues here? Where are you living?
State Route 123 with my family.
What's the post office?
45, State Route 123, I believe.
Post office? What's the name of the village or town?
I believe it's Chesapeake.
Chesapeake. Where are you from?
I grew up in Louisiana.
What are you doing here?
Well, it's a kind of long story. Started with carbide. It's a really long story. I don't know if I'm getting into it. But I moved here with family, basically. And then moved back to Louisiana. Most years. I was a long story for long ago.
Well, I'm trying to figure out why would you, what's your explanation? Do you have an explanation for this?
I needed money. I was hungry. I didn't have a job or anything going like at the moment. I don't know. It was dumb. It was really dumb. I should have done it. I regret it. So I get some money real fast. I made a bad decision.
Okay, well, I don't know if it's going to show anything at this point because you've been in jail for a while, but I still want you to do, let's do a urine screen and see what it shows. Go do a urine screen. Yes.
State of Ohio versus Aaron Runyon, case number CRA 25271.
Sir, are you Aaron Runyon?
Yes, sir.
Mr. Runyon, I'm Judge Capper. This is your what's called arraignment hearing, purpose of which is to tell you what the charges are. And you have a right to remain silent. You don't have to say anything. You have a right to have an attorney, have one appointed if you can't afford one, to have bail, and to make the state prove any charge against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
The charge against you is possession of a fentanyl-related compound. States alleging on May 7th in Union Township, you knowingly obtained, possessed, or used a controlled substance that had a fentanyl-related compound in it. So that's a felony, 5, maximum penalty, a year in jail, $2,500 fine. Do you understand the charge?
Yes.
Do you have the money to hire a lawyer?
Yes, sir.
Do you have a job?
Yes, sir.
What do you do?
Contractor. I do car carpet work.
For yourself or somebody else? Okay. I have to determine what your income is. Do you know what you make an average week or month? What can you tell me?
Probably $1,000 per month.
Okay, well, if that's correct, you're eligible for court-appointed attorney. So, Mr. Stratton, I'll appoint you on this one. What's the state's position on bond? And I've got a Huntington address for you, Gill Street. Is that right?
No.
What is it?
It's 720 Jefferson Avenue.
West End or?
Yes.
Are you from Huntington originally?
Well, Jesse.
Okay. Mr. Hill.
The state would not oppose an OR bond if Mr. Runyon were to go ahead and agree to be assessed for some treatment.
I don't think you have any problem with that, to assess the treatment. And I think, since this is going to find out that we can keep it here and see how he progresses, maybe get an assessment.
Do you have, how do you pay for medical services? Do you have a medical card?
Yes, sir.
Okay. RRS is
Well,
one.
I'm not sure if I do or not, actually. I'm like that, but I'm not sure I did.
Where did you last have one? West Virginia medical card? Still want to talk to him? Okay. RRS is going to talk to you. I guess we'll come back after they do to see if you're eligible and how we're going to proceed. So our treatment provider's going to talk to you, and then we'll come back in the court after that.
State of Ohio recalls Nicholas Meyer, case number CRA 25270 and CRA 25269.
So, wait till he gets out here. He has, I see the Rule 4 out of Washington County. The Franklin County one is kind of puzzling.
Nicholas Meyer.
It seems like that's a little raised on that one. That's a misdemeanor one. And wrong, so. He has been doing very well in treatment.
The one from Washington County is from the Common Pleas Court.
Yes. And that's not a radius.
It says one, will extradite from anywhere in the United States.
Yeah, but the other, Franklin County is misdemeanors, and it doesn't even have a radius on the one. So, Your Honor, at this time, we're ready for Rule 4 on the Washington one, and I guess both the way on the Franklin one, but I don't know if there's anything to waive there. That warrant's been apparently outstanding since 2021, and
December 15, 2021.
and it never came up this entire time that he's been treated. He's been doing very well in treatment.
Well,
Jeremy here was our advocate, so I'll attest to the fact that he's been doing very well in treatment.
was that through this court, or how did you get there?
Yeah. We are set for a prelim on the 30th, Your Honor. This month. That's why I was surprised that he was in custody. I thought something might have happened. But he's been doing very well.
He's been very compliant with those groups that I see.
Yeah, how did it come about that he got arrested?
I got there and I came to.
Go ahead.
Okay, so I was working, I came home, and while I was at work, Sal was down there, I called me to Virginia Capital, I'm sure you know who they are, and he asked me why I lived with them, and that night when I got off work, him and 3 other officers came to the house and arrested me, and they said I was in warrants. So I didn't get pulled over or anything, I was at the house and out for the warrant again.
Okay.
I was full compliant, I didn't remember anything about it.
Well, what we could do, Mr. Stratton, I could, and there's a lot here because we got 2 courts to deal with. We could keep him here, let you contact these courts and see if they're willing to let him continue in treatment, or if they want to come pick him up.
That's what I was thinking, Your Honor. Contact Washington County.
If you could also contact them, I don't want to make a fine payments, I think they didn't get me for absconding, they got me for contempt is what I was told. So I think it's about like 9 paid fines, court costs. So if you could call them about that, and I think we'll get payment.
That's a new warrant out of March 25th out of Washington County.
Yeah, it's probably the first one to call.
Washington County says it's a community control sanction violation, I think.
The only thing I'm thinking there, Your Honor, is that since the warrant's been signed by a judge, I probably want to see him.
We approach.
Yes. We're gonna need that file, though, I don't have his. Yeah, let's get his file, existing file here, recall, and why don't you talk to him about it, make sure he's on board with it. So we'll recall this later. Yeah.
State of Ohio versus Andrew Curry. Case number CRA 234648 A and C, CRA 23463, CRA 23291, CRA 2361, CRA 22351.
Hey, John. This is Mr. Steyer's case. I reappointed. He may be in the back.
Mr. Steyer's on his way, Your Honor.
My apologies, Your Honor.
That's fine.
Mr. Curry is prepared to admit that he missed the review here on April 21st. He was out of town working. He owes money to Chesapeake Village Court, Mayor's Court as well. That is going to keep him held no matter what we do here on this. He's given me some phone numbers to get some people to try to make a payment. He believes it makes $50 payment. They'll release their hold, but at the moment he's held by them. Is there a hold from Chesapeake? I'm not sure. Okay, you don't have that information. Well, he believes there's a hold from Chesapeake. I'm going to ask at this point, he understands he owes at least money. I'm not sure there's community service involved here. Or just money, I think you're probably both. I'm going to ask that he be sentenced to time served on this, and that he be released with the understanding on his part that that doesn't mean he gets out, but he's also apparently got a order from Chesapeake Mayor's Court. And I'm going to attempt to contact some folks for him and try to get that paid to get him out, and then he needs to start coming in here and work, at least doing some work on the community service, and then maybe eventually that'll transition into fines and costs.
Mr. Hill, do you take any position on it?
Oh, I guess I just continue to wonder about that property, whether there's been any movement towards
Supposed to be cleaned up?
I would say the stuff has eroded back into the soil since it's been so long, but if he's made any effort to clean the property.
That's no longer pending though.
Well, I mean, he pled guilty to it and,
Right.
and he was supposed to finish cleaning up the property.
Go ahead, sir.
We're working on it, but my truck frame broke in my truck, when I get rid of the truck, so we have to haul stuff in and out of there. But the people across the street, they've been honest and nice with them with dumpster. They said we could drop 2 or 3 bags of trash in there to get that cleaned up. We've been doing that little by little, both of them, me and Ms. Walton. But we're working on it, and we're doing the best we can. I mean, it's a slow process. I mean, getting out of jail, that's our mess up, our responsibility in life, you know what I mean? We're working on it.
I do have a new solid waste management guy now.
We don't need a vehicle no more.
Yes, Mark Wilson.
How you ready?
Yeah, from Ironton.
So we got people next on there, wanting to put over there, throw a couple bags of trash in their own dumpster.
We
Anything else?
we have a new solid waste officer, it's Mark Wilson, who I know very well. He used to be an Ironton police officer. So we got somebody new to contact about it. And so I don't take any position, we don't take any position on how the court sentences him today, but when he gets out, we wanted to continue to clean that up.
Okay, what I'm going to do is find you in contempt for not coming to your review hearing. I mean, this has been going on so long, you need some time for not coming to court. can't just come in, skip out real quick. So I'm going to order him held in the jail until Sunday at noon. He can be released Sunday at noon on Mother's Day. That'll be your punishment for not coming to court. Now we give you a new date when you got to come back for your review hearing. Your next one. Okay, let's make it June the 6th, D-Day, first Friday in June. You got to be back here 9 a.m.
June 6th, 9 a.m. Be back here at
for your review hearing. And do work on your case between now and then. Get stuff done. You go to community service, you go to find some costs.
You've been in jail for Sunday. You've been in jail for Sunday. Through Sunday.
At noon. I'm letting him out at noon, so he's getting out in time. Don't know if your mother's still living, but you can pay your respects to your mother.
Okay.
On Mother's Day.
I'm out here. June 6th, you're going to be here that day.
Okay, that's all.
Thank you, Your Honor.
State of Ohio recall James DeMint, case number CRA 24786, CRB 24787A and B, CRB 24635, CRA 24290.
What case was just called out?
James DeMint.
James DeMint.
Mr. Smith's case.
Hey, we approach Sean.
But there was no place for the officer to sign, so we refused him. Somehow we still found
I may or may not be on. This, I don't know if you've seen it, that was
Jim Mason, I talked to an officer about this case, he's already called. Oh, okay.
next weekend all that. And then we'll, that weekend, then we'll see. That 3 games in the tournament. Did you see the pictures? Yeah, sure does. Of the, that's good. Oh, that's right. You know Jay, right? Based on please and all this stuff.
Your Honor, talk with Mr. Mann and advise him of what the state's offer is. Please, if I still understand it, that they would amend the felonies and misdemeanors in exchange for a plea. Essentially, 2 consecutive 180-day commitments to the county jail, but with the possibility of getting out early, actually maybe
The treatment's not getting out.
Well, I'm getting on the county jail, inpatient treatment, I believe RS said they, you know, we're going to take it back, I understand.
Well, I'm not making any commitment that I'm going to send him there either. I'm not sending myself to.
But there will be someone who will take him and then probably has to, that one to change his plea through amending it to the misdemeanor.
Okay, so that's 24,786 and 24,290 are going to be amended to misdemeanor, first degree misdemeanors. And keep the same section numbers.
On the possession, we can do that, but on the failure, yeah, I guess they both have misdemeanor.
Now, there's other misdemeanors still pending. Do you want them to remain pending, or how do you want, or are they?
I anticipate that he'd plead everything.
24,786, and there's a 787 too, that's a misdemeanor. It's criminal damaging. And that's probably going to open a restitution issue, because it was that there was a window of a vehicle broken out. And criminal trespass. So is that something he was willing to plead to also?
As far as restitution, I don't know what, if there is any, what the amount is, or, but my understanding is he's going to plead the charges misdemeanor, send together.
Well,
Well,
I think what we need to do, I'm seeing is, there's an allegation that there was a window broken out of a vehicle. It was in December. I'm sure those people haven't been notified. They wouldn't know he's going to be here today about restitution. So let's lay it over, give the state time to try to get in touch with them. And then he was going to be in jail anyway, so let's let the state notify the complaining parties on that case, and then we got 24,635, which is a misdemeanor. And I think that was one involving a check, wasn't it?
that one we tried.
Okay, is that not pending anymore?
That's not.
Then the only other thing is the traffic matter, 23-18-59. It's still pending. It was driving without a license and failure to control, so that shouldn't be a problem. But the one with the criminal damaging is a problem. So let's get the victims notified, come back in a week, and then we can address whether it's going to be restitution or what input they have on this.
That's fine.
Are you available? That's the 16th. Are you available? Okay, so I'll pass these till the 16th for preliminary hearings and pre-trials and everything. The state needs to get in touch with those folks. I think Mr. Sowers wanted his bond revoked, which was $20,000, so that bond is terminated, and I'm going to impose a new bond of $100,000 cash and surety. So I don't want you out. Next hearing, May 16th.
And then we get involved in engineering, that's the last things we've done on that.
Yeah, I didn't have anything in my notes that was tried, so we'll look into that further. It'll be on the docket then too.
We tried it without Mr. He didn't appear with the trial, we tried it without testimony.
From Harlow's. Well, let's check, and there needs to be an entry on it.
Yeah, that was a few months ago.
Okay.
So we'll just come back next Friday. Check on that one.
State of Ohio recalls Stephen E. Hall, case number CRA 19399, TRC 191406, A, B, and C, TRC 0767.
We have to do just a minute to get all this information.
Okay. All right, let's hold, we're going to hold that while she catches up on those minutes.
Judge, I think we have a resolution. I spoke with Mr. Keel, and he, the identity fraud was actually gave a false name, so he's agreed to make that everyone obstructing, to obstruct the officer by giving a false name. Enter a plea to the guilty plea to that, amended charge in DUI, and also declare to appear. Mr. Guilty recommended 60 days in jail with, he would serve 10 days, this is 50 suspended. Whatever fine calls me up before whatever month probation.
Okay, the identity fraud you want to amend to Obstructing?
That's what, yeah, that's what.
Do you have a statute number for it?
Case numbers again.
19399.
It's 292131. That's the second degree misdemeanor.
29 what?
292131.
It didn't take.
I see that.
Okay, now it did. Okay. To the amended charge of obstructing official business, how do you plead? All right, you have a right to make a statement. Mr. Hall, do you have anything you wish to say, or Mr. Smith wish to say?
I don't think the judge was my client. Fine, sir.
Okay, on the obstructing official business, I'm going to impose a $500 fine, or you pay the court costs. 90 days in jail, and I'll suspend 75. I'm not agreeing to the 10, so it's going to be 15. I'll give you credit for, well, you came in yesterday?
No, he came in the 6th.
The 6th, that's Tuesday. Credit for 3 days. Set a review hearing for him. June 16th. Two years, level 5 probation. Don't charge an identity fraud. Then there's 191406, A, B, and C. $1,000 fine, he refused to take tests. So it'll be $1,000 fine. Court costs. And here's another way I'm going to get you. I'm going to make your, I'm going to make it a 3-year license suspension. And that'll follow you into Kentucky. So if you want it back earlier, you're going to have to show me compliance with what you're ordered to do. So you can run back to Kentucky and never come back here, but your license suspension is going to follow you to Kentucky. I don't know if you care about that or not. A lot of people don't care if they got a driver's license or not. They're going to drive anyway. So, 3 years. You want the days or, okay.
That's what I'm trying to get at.
1,095 days.
Starting the day of the violation or today?
Starting today. Okay, 180 days in jail. Suspend 165, credit for 3. And it'll run concurrent. Also order him to do 60 hours of community service. Two years of level 4, let's make it level 4 probation. He still has to do the dip school, that's required. Driver intervention program. His review hearing, what did I say, the 16th? June 16th. On the distracted driving, $20 fine, failure to control, $20 fine. Then he still owes community service on his old case, $769. So it'll be set for a review hearing on the same day, June 16th. Okay, that's all.
Thank you, Judge. State of Ohio recalls James Griggs, case number CRB 25-254, Amen City.
Your Honor, again, how many days did you tell me that was? His license suspension,
1,095.
95.
Okay, I ordered him to do urine screen, which he did. THC was the only thing it showed. So we can go ahead and conclude this. We need the numbers 25-254, A, B, and C. 25-254. Anything else before I do the sentence?
Yes, correct.
Possession of criminal tools. I did a $200 fine. Court costs. 60 days in jail, 50 suspended, credit for 10 served. I'm going to order that he does 5 days community service, 2 years of while before probation. I'll set his review hearing for November 7th of 25.
November, what was that, Mr.?
7th. Attempted theft, $200 fine and costs. Criminal mischief, $100 fine and costs.
Your Honor, will there be costs on both of the B and C case?
No, just one, I'm sorry, just the cost on the first one. They're all related, so there's only a cost on the A case. Okay, that's all.
Thank you, Judge.
State of Ohio recalls Aaron Onion, case number CRA 25-871.
Your Honor, Eric was certified out arrest and we can't accept it.
RRS is willing to accept Mr. Runyon into treatment. Do we need ankle monitor on him? West Virginia resident.
I think that might be appropriate, Your Honor.
Okay, I'm going to release you to treatment with an ankle monitor. So what happens on this, and you need to understand, it's really important, this is not a joke. If you cut the ankle, the only way to get away with an ankle monitor is to cut it off. But if it's on you there, I know exactly where you are. You can run back to Huntington, Buchanan, McDowell County even. Now, it may not work in Buchanan County, let's be honest, but it probably works here. There's no place you can go to get away. The only way to get away is cut it off. But you know what's going to happen then? They're going to charge you with a felony for cutting the ankle monitor off, and everybody that's done it has gone to prison. So you got a good chance of going to treatment, getting clean, and even getting this case dismissed if you get clean. So here's your choices. Prison on the one hand, or cutting the ankle monitor off, or getting clean. So which is it going to be? Okay. And even though I had this talk with everybody, I've had about 5 people cut the ankle monitor off, even after I tell them, you're going to go to prison. And every one of them has gone to prison for cutting the ankle monitor off. Am I telling you the truth, Mr. Stratton? And it's going to be out of my control, because then I know it's kind of complicated the way the system works. This is the misdemeanor court. This is not the felony court. But they are going to take your case to the felony court, and they're not going to send you back. You won't even be dealing with me anymore. You'll be dealing with a different judge. And they want to make an example out of everybody that cuts their ankle monitor. And they've sent everyone so far to prison. Now, I'm not talking about 6 months. I think the least anybody's got is 3 years. 3 years for cutting your ankle monitor off. Okay, so you still want to do it. And you won't be tempted to cut your ankle monitor off. Yeah, it's stupid, but believe me, people make stupid decisions. And I've had people right in this court make stupid decisions. I don't know if they thought, well, this is like my parents, they don't really mean what they say. No, this is what's going to happen to you. You grew up that way doing, I see it happen all the time. Parents promise this, you do this is going to happen. It doesn't happen. And they know that. This isn't like that situation. This is going to happen when you cut your ankle monitor off. Okay, I'll release you with a GPS monitor to RRS. And then the state's gonna keep it here. You're not even gonna go to, your case is not gonna go to the grand jury, you're not gonna get indicted. That means you can't go to prison if you don't get indicted. So as long as you do well, you're gonna stay here in this court. I'm gonna monitor what you're doing. But if you mess up, then your case is gonna go to a different court. You're gonna get indicted. Indictments, going to a felony is so serious, you gotta be indicted by the grand jury. That's what that means. You don't want that. So just keep it here, do what you're supposed to. And the girl that's in the back, did you see her back there? Okay. She's here because she didn't do what she was supposed to do. She wanted to argue with everybody, bark out orders, tell them when she's going to do stuff, how she's going to do it, when she's going to do it. That's not going to work. Okay. We'll see you back in a couple of weeks if you're available then, Mr. Stratton.
Yeah, what date?
So the 23rd?
23rd is back.
It's bad. How about the 19th? Okay, we'll see you, not quite 2 weeks, May the 19th, and I'll get a report. You're going to come back periodically, and I'm going to get reports as to how you're doing. Okay, get me good reports. It's pretty easy, just do what you're supposed to do.
We have a time limit.
$2,000 signature bond, and there's a time waiver. So we need to get in touch with adult probation to get the GPS monitor.
State of Ohio recalls Nicholas Byer, case number CRA 25269, CRA 25270, and CRA 24721.
Your Honor, I gave toward the end of the file, the case here. So I understand the state's willing to reduce capability for all felony down to one falsification. We'll plead guilty to that. We'll send it back to stipulation of guilt. Then we'll waive our Rule 4 on the Washington County case. And I guess our Rule 4 on the Franklin County case too.
See who shows up?
Yeah. I don't think Franklin County will show up on that.
Okay.
So, that should take care of this case here. I just asked for time to serve on that case.
State's agreeable?
Yes, Your Honor.
All right, so 24/7/21. There it is. Okay, it's, just change it to a new one, same statute number. $100 fine and court costs. $60 days in jail. How many days did you serve?
4 or 5.
I'm sorry.
Like 4 or 5 so far.
Okay. I'll suspend 55, give you credit for 5. Yeah, I'm going to set it out November the 7th before you have your review, so.
Okay, so I don't have to worry about the other day anymore?
No.
No, November 7th is going to be your review hearing. So you got to be here, or if you're in custody, you can't be here.
Yeah.
That's a good reason for, well, it's not a good reason, it's a sufficient reason, legal reason for not being here. But you need to get in touch with the court as soon as you get
So
released.
outside paying the thing and then when you come back?
Still need to come back.
Okay, gotcha.
What's his bond?
2,000, well,
On the Rule 4.
can he post a bond? No, he can't post a bond, yeah.
I can respond.
If you can post a bond, I'll let you go turn yourself in.
Okay, I can respond today. I got $1,000 saved up. I've been working, I work hard. I'm here 5 months.
Okay, I'll set it at $2,000.
Okay.
Cash or surety, so you can use a bail bondsman.
They pay
And I'm gonna order that you go turn yourself in Washington County first. And that's the closest.
Well, I need to do that anyways, I was waiting to finish my case here.
It's the most serious charge.
You just had a bond on the Washington County case, and so on the second county.
I'll give him an OR bond on it. So that's the misdemeanor.
That very question works. So how does that work? Do I call somebody that calls hours today?
Yes.
And then I'll have a certain amount of time for them to get me, or does that work?
Mr. Cooper's gonna, so let's put it back on the docket. He'll need to sign the waiver too. I'll set an OR bond on Franklin County. You still need to take care of it somehow.
Yes, sir.
I suggest contacting them and say, I want to take care of this. What can I do to take care of this?
When I called them, when I first got this new charge, I called my PO from Washington County, and I called it from Franklin County, because I assumed that those were going to be already picked up the whole country anyways, or at least statewide pickup. And Franklin County told me when I caught this charge, that you guys were, that it was just a fine and payment thing, and that they was looking at only not coming to us if I pay my fine. And when I called Washington County, they said it was also looking at that home, and that's why I didn't additionally have to do.
Well, that's not what it says on the warrant. It says,
That's all it says now, but that.
it says national.
Yeah, it didn't refile on the 25th of March or something like that, so I guess.
The Franklin County doesn't have a pickup radius, but the one in Washington County says national.
No, yeah, that's what it says, so I need to handle that one, they said.
So, you're gonna try to postpone today. I'm giving you till 4 o'clock today to postpone.
I can postpone 100%, sir.
Okay.
We already contacted you, that's in the
So we'll put it back on the docket then for a week from today to make sure you have shown up in Washington County.
What days are they doing?
May 16th.
Until then, show up there, sir.
Yes, sir.
Yeah.
And if you bond out, RS will be
We can provide transportation up there for you and send the advocate with you.
That works.
Okay, good luck. Take care. We'll get this all wrapped up. That's part of getting clean. Take care of your past problems.
State of Ohio versus Gary Cassini. Case number CRA 25253.
Is this on bond?
It is, Your Honor. I wrote it down for the easier to get now. I spoke to his family, they believe they could beat $1,000 cash surety bond. The state is agreeable to that figure.
The state is or is not?
Yes.
Is.
State is agreeable to that.
Okay, I'll modify it then to 1,000 cash or surety
And
with the protection order.
And protection, we have no problem with protection order remaining in place. I don't recall, I didn't see on here that we had set a date, so have we set a date back?
When do you want to come back?
We can go outside the 10 days since he's out of jail. That's the board's preference. What do you want looking to set things?
Well, next Friday's not terrible. Anytime after next Friday or after.
The 23rd is actually pretty bad for me, so I'd like to stick with next Friday if we could.
Okay, the 16th?
Yeah.
Next hearing for Mr. Kazee is next Friday, May 16th, 10 o'clock.
Your Honor, how much was this bond?
1,000 cash or surety. You're letting Mr. Sowers know?
No, Your Honor, I'm helping you.
Oh, okay.
Wrong.
I'm sorry, Your Honor, on the buyer, did you want the cash or surety bond to roll to all three cases?
Yeah, yes. Well, I gave him an OR on the Franklin County.
Okay, but not on the Washington County?
No,
It was
I wanted to go there first.
so on Washington County, it was a cash or surety bond.
2,000.
I will contact Mr. Talley.
I sent him a text saying there's several contracts. I didn't give him the details.
I did on the.
It's fine.
State of Ohio versus Team Unit Wells here at the court. Case number CRA 24604, CRA 141276.
Yes.
Yes.
Judge, it appears to be a very good report. I think we're proceeding in the right direction. I would defer to Your Honor as to the state is a good comeback date to review this again.
Let's go to July. Any of the dates in July?
The only date's bad, I have mediation in Huntington at the 25th of July. Other than that,
July 7th?
we'll be fine.
Thank you.
Okay, good job.
Thank you, Your Honor. Thank you.
State of Ohio versus Jonathan Gibson, case number CRA 2597, CRB 2598. Mr. Tyler Smith's case.
May I approach, Your Honor?
Yes.
Mr. Gibson did have a slip with Wellbutrin, and other than that, he's been an excellent client.
Okay. So is he back on track now? Because he got a 2-week penalty, basically.
Yes, he's on track, and I mean, he's been accountable, and he was very honest when he was confronted with the results.
So he's not that far into it, I would say, continue.
Yes.
I think Philip, what you said, I know that, okay, and then we'll discuss that, but he just started.
There's a theft charge as well as a possession charge, and I had spoken to Mr. Smith about the fact that we need to get that resolved sooner than later. And I had offered that if he were to plead to that today, that we would ask to delay the sentencing and let him go ahead with his treatment that he's already started to be successful in. And if he continued to be successful and finished his treatment, we would not ask for any jail time on that. If you wanted to do that, if they want to come back another day and talk about it today, but it does need to get wrapped up very soon.
Yeah, okay. All right. I believe, talking to Mr. Gibson, he said he'd be willing to plead to the theft and just delay sentencing and continue with treatment, and then we can address the other charge later on. Hopefully, he successfully completes and this all gets resolved at that point.
Okay. Do you agree with that, Mr. Gibson?
Yes.
Okay, I'm going to accept your guilty plea, but I'm not going to sentence you. I'll just delay it, let you continue in treatment. And of course, the better you do in treatment, the better I can do in sentencing down the road. Hopefully, you've got a felony possession. You get that dismissed by being successful in treatment. You won't even have that on the record. So let's, we were a little less than a month before your last time. Let's go about a month out for your next hearing. So I'm looking second week of June. Mr. Smith, what's your schedule?
Your Honor, I can do the 13th or the 6th. I'm not available the 9th.
Let's do the 13th.
Okay.
June 13th will be the next hearing for Mr. Gibson, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus Davin J. Leonard. Case number CRA 25195, CRB 2543, CRC 25619, AMD. Davin Leonard.
Mr. Smith's case set for preliminary hearing. And pre-trial. Yes. It's a good report. Good job.
Thank you.
I'm assuming this is one of those where the state wants some commitment as to what's going to happen on the OPR.
Yes, Your Honor.
It's been 5 days in jail while he's in treatment, so one of the court.
Yeah.
That should be. Talks out. So you keep on treatment. Your Honor, I believe that talking to Mr. Leonard, he did spend 5 days in jail. He is in treatment, so I think that would definitely cover the theft charge, the misdemeanor theft, and the OPI. And he'd be willing to enter pleas. And of course, he has I believe, a felony possession, which is more pressing matter. He's in treatment now, so I'd ask to continue treatment and hold that off.
So,
I believe the state's okay with that.
this, what I would prefer to do is go ahead, but if he wants to enter a plea, I'm just going to delay sentencing, because it's not like there's a mandatory jail he's trying to get out of.
Right. That's fine, Ron.
Okay. So he's pleading guilty to the theft and the OBI?
Yes, Ron.
Is that correct?
Yes, sir.
Okay. So I'm going to let you continue with your treatment. At some point, I'll sentence you on those two. You've got a pending possession. You can get that dismissed if you do well in treatment. And that's a felony, so that's the most serious charge. But you have these pending, and I'll send you down the road once I see how you're going to do. Right now, you got a good start. So let's come back for the next hearings. June 13th, I think we just set
Yes,
some for you again.
that's fine.
Set these for them, June 13th. Actually, be sentencing on those misdemeanors. And preliminary hearing on the felony.
All right, thank you, Ron.
You are.
State of Ohio versus Troy, Dwayne Edwards, that's case number CRA 24594.
Mr. Stratton's case. Thank you. RRS now?
Yes.
Yes. So this just started this week with RRS, right?
Yeah. It's very positive, though.
It's a good report. Let's come back in about a month. What's your schedule in June?
Any day except the 2nd and 9th.
2nd and 9th, okay,
Yeah.
16th.
You okay?
June 16th would be the next hearing.
June 16th.
Thank you.
All right.
Thanks, Mr. Capper.
You're welcome.
State of Ohio versus William E. Harkis, case number CRA 25778.
Mr. Shrek's case.
That's the judge. You're on the approach.
Yes.
Just before now.
I'm not sure how the state wants to proceed with that letter.
OVP aware of the circumstances of the charges against him?
Yeah, I mean, they're aware that this is a referral from the court. I mean, they're.
I mean, he stopped and he admitted to purchasing these pills that weren't prescribed to him, that were hydrocodone. And they're saying that he didn't have any problem.
Yeah.
So I just wonder if they really know what the circumstances are. What's the state want to do on this?
I guess I'd like something from the treatment provider as to whether they were aware of what the charge was and if they had considered the facts of that in their assessment.
Is she here? I thought I saw her earlier.
She was here earlier, I don't know if she's here now. He's doing outpatient with OVP now, right?
Yes.
Why don't we do a urine screen today and see what that shows?
Yeah, I mean.
Is she here? No. Let's go have him do a urine screen.
All right. Go with. Yeah.
State of Ohio versus Lester Holland, case number CRA 24636. Mr.
Stiers case, set for preliminary hearing. This here is a good report.
Yeah, this looks positive. This one's been going for a while. I'm not sure if the state feels we've gotten to where we're looking to land on this or wants to keep coming back.
Well, I guess that would depend at least in part on what the counselors thought.
So I know last time we were here, you were inquiring as to when treatment was going to cease for Mr. Holland. I spoke with case management about this yesterday, and they said that Mr. Holland had expressed a desire to stay enrolled in services even after the completion of this case.
Well, that's good. That's commendable anyway, regardless.
So it's been 7 months, roughly 6.5 to 7 months. I think I'd like to see him come back, maybe set it out in July and finish it then if he's still got good reports.
Okay, Your Honor. July, taking a look at my calendar. I have a jury trial the 7th and 8th, as well as the 24th and 25th.
About the 14th.
14th looks clear, Your Honor.
July 14th.
July 14th, 10 a.m.
Mr. Holland's next hearing.
July 14th, 10 a.m.
Question mark, whether to finalize.
There you go. Good job. Thank you.
Thank you, Your Honor.
You are.
State of Ohio versus Jonathan Johnson, case number CRB 2578.
Johnson is here.
Jonathan Johnson. Can't do that.
This is set for trial today.
Johnson. Just a second. He's here. He's outspoken.
Okay, go on to something else.
State of Ohio versus Thomas Lewis, case number CRB 24791, CRB 24751.
Mr. Smith's case.
Can I step through the?
Yes.
Thank you.
Yes.
Traumatic, and I have to have plastic. What you're supposed to do in your mind. Yeah.
Okay. You've seen the report and the recommendations?
I have, Your Honor. May we approach?
Yes.
No.
All right, this is on the sentencing docket. Mr. Lewis has been going to counseling with Anu, which I have their report. There's sessions that have occurred since the last time we were in court. So I think maybe we're ready to go ahead and do the sentencing here today. It's my understanding that the daughter wishes to make a statement.
That's correct, Your Honor. Her name's Tommy Lynn.
All right, ma'am, you can go ahead and make a statement if you wish to.
I still feel like he should get punished for what he did when he hit me 4 times in the face, which that was at a Huntington McDonald's, but the officer that I wrote my statement to, he had went and checked the Proctorville McDonald's and South Point McDonald's around the time that happened, and he did not see his car pull in there. So, and he stated that it had happened not at the Huntington place. Sorry, I'm just...
Okay, take your time, say whatever you think you need to say.
I haven't been able to heal this. I'm very trying times, and I'm struggling to even be here to do this. I'm trying my best.
And you're in school now?
Yeah.
What grade?
11.
Where do you go to school?
Sims Valley High School, but I'm in Collins Creek.
Okay. Are you having any kind of visitation with your father now?
No.
Do you want any kind of visitation with him?
No.
All right. Mr. Smith.
Judge, we've been through this before. My client admitted he made a mistake. She was saying vile, vulgar, and hateful things to him, and he backhanded her. He does not admit hitting her 4 times at the McDonald's in Huntington, but he did admit he stepped up and shouldn't have done that. I've lost my cool since then. Everything, he's gone to Anu, he's doing what he's supposed to, there's no contact with him. I understand that he's entered a guilty plea, but I don't think incarceration at this point will serve any purpose. You know, I would ask that whatever sentence is imposed, that it be some type of suspended sentence, he be ordered to probation as the court deems appropriate, whatever other sanctions the court believes are appropriate, given this is, he regrets this happened.
Mr. Hill, anything you wish to say?
Your Honor, given the seriousness of this, and particularly urging this young lady and her mother, that they consider this to be a very serious thing. The part about the punching in the parking lot at McDonald's in Huntington, it was a continuation. There was also violence that occurred here in Lawrence County. So we do kind of consider that what happened in Huntington as part of this as well. So the young lady and her mother think that Mr. Lewis should spend some time in jail. So I don't have any specific recommendation on that, but we feel that it's that level of seriousness.
Anything else?
That's all, Your Honor.
All right, on 24-751, I have no jurisdiction over what happened in Huntington. You can file charges over there if you wish to. I don't see, from what I've observed, I don't see this as worthy of jail, so I'm going to give a suspended jail sentence. I'll impose a $200 fine on the domestic violence. I order the court costs be paid, 10 days in jail suspended. I'm going to order that Mr. Lewis continue with the counseling at anew. They recommended that he have family counseling, but I don't see that, you know, the other side is agreeable to that, so I can't force that issue. I think it's a mistake for you to terminate your relationship with your father, but that's something you get to make the decision on. I'll set a review hearing for November the 7th of 25. On the violation of protection order, I'll impose a $100 fine on court costs. Level 5 probation, you'll need to see Mr. Major in the probation office before you leave.
And we'll also ask for no contact order.
Okay, no contact order on the domestic violence.
Thank you, Judge.
You are.
State of Ohio versus William Gibson Jr. Case numbers CRB 10-1078 A and D, PRC 2-432 A, B, and C.
Okay, this is on the sentencing docket because Mr. Gibson has a bond now, and he's making payments.
I paid my fines off.
And community service.
Your Honor, if I may, I believe the community service, he's been, I think he's been here 3 or 4 times since the last meeting.
Okay.
He done clean up day and
All right, next hearing will be June 9th for sentencing, 10 o'clock.
State of Ohio versus Donald Waddle, case number TRD 22-1371.
And this is on the sentencing docket because the bond is now. Have you done any community service since the last?
I got 3 days to do. I haven't had time to do it. I've been working.
I would have to check.
I haven't done it. I'm gonna make a payment today though.
Have you done community service since your last time here?
No. I work for myself and been
How
working
much are you
for
paying on the bond?
$50.
Okay, well, you gotta get this done. I want some community service in the next time frame.
Okay, yes sir.
Mondays or Fridays for your reviews?
Friday's fine, Judge.
Actually, it's sentencing, so June 20th for sentencing. 10 o'clock. Go to the clerk and make your payment.
Thank you.
State of Ohio recalls Jonathan Johnson, case number CRB 4578. Well, this was set for trial today, but Mr. Steiner informed me that we will testimony.
All right, this is on the trial docket, but I've been informed there's some resolution reached.
Yes, we have an agreed to recommendation, which would be that in exchange for a plea of guilty to the charge that's pending, which is a single count of misdemeanor domestic violence, that Mr. Johnson we would agree would be sentenced to 180 days in jail with 120 days suspended, so he'd have 60 days to serve. Did you have any time in jail on this already?
1 or 2 days, I believe.
Would you stipulate to 2 days credit served, Mr. Hill?
If that's what it was. Yeah.
Well, that's why I'm asking if you stipulate.
Yeah.
Okay, so 2 days credit for time served, so 58 days to be served at this point, and he has his belongings with him so he can report immediately. In exchange for that plea, the state believes that there's a possibility that this could have been filed as a felony. They're agreeing they will not do so. Further, there's a possibility that an arson charge would arise out of these events. They're agreeing that no arson charge will be filed. So no other crimes will be charged out of the events that gave rise to CRB 2578, and we're accepting that agreement and entering into the agreed recommendation.
Now, I'm assuming this must be Jennifer Short that's in court today?
Yes, sir.
Have you been consulted about what's being proposed to the court, ma'am?
Yes, sir.
And do you have any explanation or statements you want to make to the court about this?
I'm fine with the agreement.
Okay. Do you want to, I can do a no contact order where he's not allowed to contact you. Do you want that?
Yes, sir.
Okay.
And we're agreeable to the same, Your Honor. So we're going to have you sign. No. Does he sign here? No, that's not for him. He signs. No? He signs here. That's all right. I want to make sure it's not somewhere else for him to sign as well.
Yes, the defendant signs.
All right, Mr. Johnson, you've heard what your lawyer said in court, correct? You were here for that.
Yes, sir.
Do you agree with what he's representing to the court?
Yes, sir.
So you are entering a guilty plea, and do you understand, one of the things I want to make sure you understand, this is one of those things like OVI, used to call it DUI. If you plead to it or get convicted of it, it can have an enhancing effect down the road if you get another one. In other words, the penalties go up each time you get one of these. Do you understand that?
Yes, sir.
That's one of the consequences of having a conviction on this. If you get another one, it could be a felony. And you understand that?
Yes, sir.
Okay. You still want to enter a guilty plea?
Yes, sir.
All right, I'll accept your guilty plea. I'll impose what was recommended to the court. I'm going to impose a $500 fine. I'll order you to pay the court costs, 180 days in jail, suspend 120, give credit for 2 days served. He's going to go today to serve 58 days in jail, starting today. There is an agreement, no additional charges will be filed out of this incident. These are the only charges. He'll be on level 4 probation for 2 years. There'll be a no contact order to not go around or contact Jennifer Elaine Short. That will be entered. I'll set a review hearing for him for November the 7th of 25. And let's have him talk, go speak with Mr. Major, and then he can make arrangements for his transport.
Yes, Your Honor.
To the jail.
And, Your Honor, I know in some cases, if an individual completes all their obligations as far as fines and other things, that maybe sometimes probation is ended early. We'd ask that the full 2 years be held.
Keep the no contact order.
Yes.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Alexis Destiny Smith, recall case number TRC 193668A&B.
All right, do we still want to have an evidentiary hearing on this, Mr. Morford?
Yes, Your Honor.
Okay. Well, I need Mr. Hughes. Case number is 193668. Okay, we're going to have an evidentiary hearing on the circumstances of her discharge from hometown recovery. We've got a representative from hometown here. Ms. Smith has not admit anything.
Your Honor, this is Crystal. She is a counselor at Hometown Recovery. She's not Alexis's individual counselor, but she was doing case management that day. So if it would be okay if she stood on behalf.
Well, if she observed things, she can testify to what she observed. Mr. Hill?
Well, we'd like to call her as a witness then.
And if you come up to the witness stand, I'll swear you in. Raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You may be seated.
Ma'am, tell the court your name.
Crystal DeLong.
Where are you?
Last name DeLong?
Yes.
DeLong, thank you.
Where are you employed?
Hometown Recovery and Counseling in Ironton.
In Ironton?
Yes.
What do you do there?
I'm a CDCA.
What does that stand for?
Chemical Dependency Counselor Assistant.
Okay. In your job there, are you familiar with Alexis Smith?
Yes.
And there was apparently recently an incident or a series of incidents that occurred there that has been reported to the court. Were you a witness to these things, and would you be able to tell the court what happened?
Yes. The day that she left, I was providing her case management, and I had taken her to the store like I was told by my boss as part of her case management. We were leaving there, and she told me that she had medications at CVS to be picked up. Well, went to CVS, tried to get them, and they said it would be 20 more minutes. So at that time, we went back to the office so I can get the information, other clients' meds that need to be picked up. Well, then we went back to CVS and got the medication, And on the trip back to the office, she said she needed to become OVP because our doctor would give her the medication that she wanted, which is gabapentin. And she called and spoke to somebody at OVP, and they told her she had to go to the Huntington or the Ashland office and to be seen, and they would continue her medication. And then she asked me to take her there, and I informed her that I couldn't at last minute because I had other services to do, and I was the only staff member working that evening too. And then we get back to the office, and even after her case management was done, I was doing other people's case management stuff. She just kept ranting and raving that she couldn't get her medicine and kept asking me to take her, and then I told her, I couldn't right now. And it just kind of escalated from there. I ended up leaving on transport while they were in the group, and I was told that she kept yelling during the group and all that. And then finally, it came down that she just wanted to leave. So, and then she packed her things and left. So.
What day did that happen on? Just in the last 2 or 3 days?
It was the day that she left. I don't know.
Okay, well, I have a letter here that says May the 7th, so that would have been 2 days ago.
Yes, that was the day.
Now, prior to this incident, had there been other disruptions and other things within the program that Ms. Smith had caused?
Yes, while I was there, it was pretty much on and off the whole shift. She would just continuously rant and rave about various things, mostly not being able to leave. Like the last day she was there, she said evening group was running her life. She pretty much didn't want to perform services. She just wanted to leave the house.
Your Honor, I don't know if there's any other questions that I would need to ask of her.
All right, Mr. Morford, any other questions?
I've got a couple, thank you, Your Honor. When did these disruptive behaviors begin, ma'am?
From what I've witnessed, several times during my shift while there.
Okay, well,
From the beginning.
can you tell me when they began, approximately?
Not right offhand. I can't remember dates or anything like that.
Did any of the incidents result in any kind of discipline or
Not that I'm aware.
modification of her case plan?
Not that I'm aware.
And she went to CVS to pick up prescribed medications?
Yes, I took her to get her medications. I can't recall what those were at the moment.
And was she prescribed gabapentin?
Yes, not by us, but yes.
I understand that, it wasn't by you, but you wouldn't let her have the gabapentin?
She said that our doctor wouldn't prescribe it for her and that she had to get it from a VP.
But she just got a prescription for it from CVS?
No, it was different medications. It wasn't that medication. That's why she was upset.
Did you have a prescription for gabapentin?
She came there, she had a prescription for it. I administered her last one that day. And when I administered to her, she would not open her mouth and show me that she had swallowed or anything. That also happened the same day that she had done.
And what were the natures of the disruptive behavior exactly? What did she do?
Well, I had someone else in service, case management, and she just kept coming and disrupting those services because she wanted to leave, and she wanted me to take her to a VP, either Huntington or Ashland office.
And when did that begin?
It just continued from when her case management session was going on throughout another client's case management. Even when I was in the office logging the medications that I picked up, she kept coming to the door and asking to leave, asking if I would take her.
She was not discharged from hometown, was she?
No, she left on her own.
On accord?
A staff member from OVP picked her up there.
Did OVP pick her up immediately?
Yes, and I I don't know that staff member's name, but yes.
You don't
Well, not
know?
immediately, no, it was like, took maybe an hour and a half, something like that, for them to come in here.
Do you remember what date that happened?
That would have been the May 7th.
May 7th?
And it was around between 8:30 and 8:45, actually.
Are you aware that she is now at Southern Hope?
No, I wasn't aware.
I believe that's all I have, Ron.
I've got some questions. Do you know if she was taking buprenorphine while she was at your facility? Did she prescribe that? Suboxone.
I think
Is the
so.
common name, okay. Any questions based on my questions?
No, Your Honor.
You may sit down and. Anything else?
No, Your Honor.
Anything from the defense?
You have to move from testify.
I mean, I have a few things to say.
What?
I mean, I have a few things to say that I feel like from different, but I also,
Do you want to get up there and explain your side of the story?
yes.
Okay. Judge, I think Mrs. Smith wants to tell you her side of the story.
All right, she understands she'll be subject to cross-examination.
Yes, I've explained that to her, Judge. Do what?
I'm confused about like someone is doing the cross-examination with me.
That means that Mr. Hill gets to ask you questions after I finish.
Understand.
Or the judge could also ask you questions.
Okay, I understand.
You want to do it? Okay. I believe she understands.
Come up and be sworn in then. Raise your right hand. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
You may be seated.
Could you tell us your name, please?
Alexis Smith
And where do you currently reside?
at Southern Hope in Chesapeake.
When did that become your residence?
On May 8th, early that morning.
Now, you've heard the lady from hometown describe disruptive behaviors. In your mind, were you guilty of any kind of disruptive behavior or creating commotion or during groups or your individual therapy?
Up until that day, no, I really didn't. I mean, I had a little bit of trouble settling in there, but it wasn't, I wouldn't consider it disruptive. They just came into my room individually and talked to me privately. It wasn't where anyone else heard or seen anything. And then that day, I do apologize because I realized that I was a little bit disruptive, and I just was trying to go somewhere that had a better plan and treatment plan for me, and I'm not trying to make any excuses. I'm really not. I'm just trying to plead my side. And I have been on 3 different psych meds that week that were just adjusting differently, and I didn't mean to act out the way I did, and I apologize about that. And I wish that I would have handled things differently, and I wish that I would have went back, or I wish that I would have came and asked you before I left, but I just felt that it was just necessary for me to get out there, out of that house before I ended up just leaving and going home, because I knew that wasn't the right plan. So I called OVP to come get me so that I didn't end up back on the street. So I just wanted to go back to rehab until I could get placed somewhere else.
Do you want to strike that? Was there an issue with the gabapentin?
Yes, because no
What
one
happened?
told, what is it?
What happened?
No one explained to me that my script was getting cut off, and I had started experiencing withdrawal symptoms from that. And they did come on strong, and I wasn't aware, and now, now that I would like to continue without them. That's what Southern Hope and me have been discussing. And I'm on the Sublocade shot now. I'm not on actual Suboxone. I got the shot a few weeks ago, the day I left to go into Southern, or the day I left OPP to go to Hometown, I got the shot.
How long a period were you at OVP, ma'am?
Before or after Hometown?
After?
Overnight.
Just
And they got-
overnight?
Yeah, they got me in Southern Hope. They come and pick me up the next morning.
And you would like for this court to leave you at Southern Hope?
Yes,
Are you willing to abide by the rules?
yes,
And you understand that you have to do what you're asked to do in the way you're asked?
Yes.
And at the time you're asked to do it?
yes,
Are you willing to assure this court you'll follow the rules and regulations of Hometown?
yes.
Or Southern Hope, excuse me.
Yes, Your Honor. I just want to apologize, and I would like to take my wrong actions that Hometown that occurred and just move forward at Southern Hope.
That's all I have.
Mr. Hill?
Thank you, Your Honor. Ms. Smith, how did you find your way to Southern Hope?
Well, whenever I was first at OVP, that was the second treatment plan that I was trying to get into, but ended up just kind of getting, not pushed into Hometown, but Southern Hope just kind of got pushed on the back burner, and there were a lot of people going there, so I just kind of let it fall off and just went to Hometown because I figured there'd be more beds there. And then after things didn't work out at Hometown, I called Southern Hope that morning and was asking them about if I could get in there and stuff, and they said, yeah, they could take me. And then after, like, that night, after things went wrong at Hometown, I didn't want to just go home, so I called Southern Hope, I called OVP and had OVP come pick me up so I could go stay the night there. I was planning on staying until a bed opened at Southern Hope, but I didn't know that it was going to open up the very next morning, so I was only there overnight, and then Southern Hope picked me up, and I've been there ever since.
So the last day that you were at Hometown is when the lady from Hometown who just testified, that's what happened that day, and then you
Yes.
ended up leaving.
Yes,
So even before that happened, you'd already talked to Southern Hope?
yes, because I was supposed to come back here on Saturday and do my community service on May the 3rd at 7:30. And from the time I got to Hometown until the day of, until 7 o'clock that morning, I kept asking. I asked Crystal that morning, I'm pretty sure it was her working, at 7 a.m. I asked her if they were going to be able to take me. I asked Missy, the worker there the night before, to leave a note, because you told me last time I was here, Your Honor, that it would be double the credit and some towards my fine. And I thought, I was under the impression that Hometown was supposed to be helping me with the court things. And when I asked Crystal about taking me that morning, she told me that it was too late and they would be able to take me, and there would be other opportunities I could do it at. And I kept explaining to her I had to come to the courthouse here to do it. And the reason I was trying to leave to go to Southern Hope that morning was because I hadn't got to go to any meetings, and someone else I knew that had been there a week longer than me hadn't went to a single meeting yet, and that's what I need for my recovery, is meetings and going with other people that are trying to get to the same things as me.
If you were to try to do this over again, so let's say you're back at Hometown and you're dissatisfied, knowing now what you know, if you could go back in time, how would you handle this?
I would wait until I could come in here first and explain to the judge how I felt and see if he would approve me going there.
You know that's the right way to do things, isn't it?
Yes.
That's all I have, Your Honor.
Nothing further? Hey, you can sit down. Any other evidence?
No, Your Honor.
I do have a question for you, Ms. Smith.
Yes.
Are you prescribed Suboxone, buprenorphine?
I'm prescribed Sublocade, not Suboxone. I was on Suboxone, but I got off of it The day I went to hometown, I got the Sublocade shot that morning.
Well, you were taking it before the Suboxone?
Yeah.
Okay. Well, it's contraindicated that, who's prescribing you gabapentin while you were taking Suboxone?
It was at OVP.
Well, I need to talk to them about that, because that's contraindicated. You're not supposed to be taking both at the same time. So that's a big problem. Well, one thing I don't understand, you get on the stand and you admit that you were disruptive. You force all of us to have this hearing, and then you get up there and admit you were disruptive. I put you back in the holding cell, and I'm going to think about what I'm going to do. I'm very close to putting you in jail. Back in the holding cell.
Thank you, Your Honor.
State of Ohio versus Corey Thomas, CRA 25-257, A, B, C, D, and E.
Yes.
And I'd like to ask Mr. Thomas to draw it down to the council table.
What is his name?
Just, yes.
If you just want
Just have a seat here for a moment. Just sit down.
I'm going to have you come down and join me at council table, please.
All right, this is set for preliminary hearings. There's several felonies pending, and there's right to a evidentiary hearing on those, so I guess that's what we're going to have.
May we approach from one, Your Honor?
Yes. All right, after bench discussion, the state's going to go forward with evidence.
Your Honor, we would call John Thomas.
That's me. What's he want?
All right, Mr. Thomas, if you would come up here to the witness stand, I'll swear you in. Get your testimony. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated, sir.
Mr. Thomas, do you have some trouble hearing?
About half, yeah.
Okay, well, I'll try to speak up.
I say nobody in here I can hear.
All right, well, can you hear me okay?
Oh, yeah.
All right, do you live at 182 Township Road, 1175 in Crawfordville?
Correct.
Do you know Corey Thomas?
Grandson,
Is he here in the courtroom?
right over there.
Ask the record to reflect he's pointed to Corey.
Yes, it will.
Has he been living with you?
Yes, for a while.
And who else lives in the home with you?
Jim Thomas, my son.
Okay, and he's here also today.
Yeah, he's back there.
Now, I want to talk to you about something that happened just the other day on April the 30th.
Right.
Did law enforcement get involved at your house?
Oh, yeah.
And was there something that happened that caused the sheriff's deputies to come there?
Yes.
Have you been having some problems with Corey in your home already?
Basically, it's been because of drugs. And
when he's not on drugs, he's a good kid. But I think the drugs has got to his brain.
Okay. Well, what happened that day on April the 30th?
What happened on the 30th?
Yeah.
Okay. I had been to Walmart, and on the way home, I got home and I went across the front porch. It was clear. And I went in the house, put my groceries on the table, took the dog and went out in the backyard. And I got a boat, a tractor, a couple of things out there that checked it all up. But anyway, the dog and I stayed out there maybe 45 minutes or an hour. So I came back in the house and I said, Corey, what would you want for lunch? And he said a steak sandwich. I said, he had my cell phone. I said, give me the phone number, I'll phone it in. I had a flip phone. He handed it to me in 2 pieces. It was broken apart. Well, I was kind of concerned about that. I went out on the front porch and there was glass all over the floor. It wasn't that way when I came back from the store. And I looked up, I had a 4x8 window. It has 4 panes in it. All 4 panes were broken out. So with no phone, I went across the street to my neighbor, Stan Wesser, and got his phone and called Jim. Then I called 911, and I stayed over there with Stan until the police came. And I told them, when they got there, I told them what happened to the wind and everything, and 2 of them went in the house to get Corey. And the third one went around my house and he came back and he said, your gas meter's going crazy. And so they called the gas company and the electric company, told me to get off the porch, get out in the yard because the house was filling up with gas. And the electric company and the gas company came, and we couldn't go in the house. Now, I'm not sure if you found the gas leak or did the deputy find it?
I'll ask the deputy that question. But do you know that Corey broke the glass?
He and I was the only one there.
Okay. And what about your phone? When he handed it to you and it was already broken?
It was broken into, the cord between the 2 pieces. It's a flip phone. And so when the house cleared, somebody went in the basement, I'm not sure it was Jim or a deputy, and they found the gas line that goes to the hot water tank had been disconnected, and that gas has been poured out that. And that was one item. Then later on the day, I went to flush the commode and it wouldn't work. It'd been turned off down there, and I turned it on, water went everywhere, and that hose had been cut. Jim went to use the washer, turned on the water, and water went everywhere. Both of those hoses to the washer had been cut. And I think what it is, it's the drugs. It's a mental thing.
So you and Corey were the only people at home at that time when all this stuff happened. When you left to take the dog outside, was any of that stuff going on at that point?
Not that I know of. Now, I was at like not the basement, but some of the stuff that happened in the house, like could have happened. Like there was a bleach that had been poured on the rug and made it white. I had clothes hanging on a hanger in my bedroom. Bleach had been poured over that, and bleach had been poured over the bed, and all that changed color naturally. And the last thing that I noticed, this was yesterday, I hadn't received my Capital One bill. Always got it on the first of the month. So I called them and they said, yes, we mailed that and everything. And I said, well, if I don't get it by the 15th, I'll call you back. So I went out and looked under Corey's bed, and I found it had been torn in two. So I put it back together with tape and sent it to Capital One. But like I say, he needs a mental health lockdown. Jail won't do nothing.
All right,
He's been there.
thank you.
You through with me?
Well, Mr. Steyer may have some questions.
This other lawyer may have some questions for you, Mr. Thomas.
Mr. Thomas, you would agree that Corey has some mental health problems based on what you said there? Had you taken any steps prior to these events to get Corey help? Had you done an affidavit or made a filing with the probate court, anything of that nature?
Not me.
Are you aware of someone who had?
Am I aware of what?
You said not you. Are you aware of anybody else that had done that?
Taking him anywhere?
Tried to get him.
Well, he went to PROACT over there for a while, and I'm not sure what they did.
Okay.
And but he doesn't follow up on things.
Just to be clear, I understand why you believe Corey did the various things you described. You didn't actually see him do any of those things.
No.
Those are all the questions I have.
I have nothing to follow up with this.
Mr. Thomas, you can step down. They're not going to ask you any more questions.
Okay.
And Your Honor, I'm going to call Deputy Atkins.
Okay. Deputy, if you'll raise your right hand, I'll swear you in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated.
Deputy, if you could state your name, and I'm going to ask him questions now.
Oh.
If you could state your name and where you are employed.
Deputy Bryce Atkins, Lawrence County Sheriff's Office.
Deputy Atkins, were you working on April the 30th of this year, and were you called to residents in Proctorville, 182 Township Road, 1175?
I was.
What was the nature of the call? Why were you called there?
It was a domestic disturbance / vandalism complaint.
And when you got there, what did you observe? Walk us through what you investigated.
When we arrived, Mr. Thomas was across the street, and he was walking back over because we were trying to figure out. I've never been to the residence. He was walking back over to us, but immediately noticed that the front windows of the house were broken out. The window of Mr. Thomas's car was broken out front. There was glass all over the place. And he came over and told us that Corey was inside. And he's the one who done it.
Did you locate Corey?
We did, so we made entry into the home. As soon as we made entry to the home, some type of gas hit us in the face. It was pretty severe.
You mean like a gas odor?
Like an odor, and it got in my eyes and started burning immediately as soon as we got inside. Wasn't aware of what it was at the time when we went in. It was just a smell and an irritation on the skin and in the eyes, and it had a kind of like a fogginess in the air. It was hazy inside the house. But we did locate Corey inside to the right in the bedroom, laying in his bed.
Did he show any signs of injury at that time?
He did not.
Didn't have any cuts on him or anything?
He did have a small cut, I believe, on his finger.
Now, I'd like for you to talk about not only the gas that you've already described, but what the condition of the residence was and what things were out of place there that looked as if they'd been tampered with.
So, initially going in, our main goal was we didn't really know what the gas or anything was inside the home, so we got him, brought him out, and then the fire department ended up getting called, and they had to ventilate the house before anybody else was allowed to go inside. It was later determined that the gas was natural gas, along with bleach and other chemicals that may have been mixed together. There was bleach poured all over all kinds of different property inside the house. We noticed that some of the water lines had been cut. I believe the fire department were the ones that found the gas line in the basement had been unscrewed from the hot water tank.
and that's what was causing the house to fill up with natural gas.
Did the combination of the gas leaking into the house plus, well, let me ask you this first, was the electric to the house still on?
I believe so.
Did that create a hazard of explosion or fire?
That with,
Objection.
I'll let him answer.
that with the other items that we found, absolutely.
Did you find an indication that the gas was disconnected for an actual purpose?
Yes, so in the basement, everything was photographed. In the basement, we found the gas was unscrewed. It wasn't cut. It was unscrewed from the hot water tank. The light bulbs had appeared to be broken with the filament still intact, appearing to be maybe an ignition source for the gas. As well, upstairs, there was a bucket located in the kitchen with paper towels that were burnt. It appeared to be tried to possibly be lit to ignite the fumes.
So as you were there, as well as, let's see, Deputy Chin was the other deputy that was there, went in the house. Did it look to you like it was at least on some level an attempt to cause the house to catch fire?
Yes, sir.
Were you able to speak with Corey Thomas about what had happened?
We didn't speak to him. I didn't try to speak to him. He was kind of talking out of his head, so we really didn't think we could get anything from him. That was, although there was a mental hygiene warrant in place as well.
When had that been issued, do you know?
I believe it was that same day, and we actually had the hard copy with us. We were planning on going to get him whenever another deputy got on shift. We wanted 3 because of prior incidents that's happened. And we were actually planning on, within the next 30, 40 minutes going to get him. And then this came in before we could get there.
Okay. Do you know, was that order issued by the Lawrence County Probate Court?
I believe so, yes, sir.
And you may not know, but do you know who actually went to the court seeking that order?
I do not know. I don't recall the name that was on there.
That's all I have, Your Honor.
Mr. Steyer?
You are a deputy sheriff.
Correct.
The sheriff's department does not issue body-worn cameras. Is that correct?
We are.
You are issuing body-worn. I'm sorry, I forgot about that. Did you have your body-worn camera operating at the time you were at the residence?
I did.
Have you caused that footage to be maintained?
Yes.
Have you provided to the state?
It should have been provided. I don't provide it directly, but the clerk should have provided that with the report, yes.
Okay, but you have looked at it and made sure it recorded?
Yes.
Okay. You mentioned some photographs were taken. Have you provided those photographs to the state?
Again, I don't provide them directly, but the clerk should have provided those with the report. They were
Okay.
attached.
You took the steps that you would normally take to provide them?
Yes.
Okay. You mentioned a mental hygiene warrant was in place. I know Mr. Hill asked you a couple of questions. We're going to try to clarify a couple more things. It's your testimony that it was issued the same day as this incident?
I don't recall if it was the same day or maybe, I don't recall the exact date. I believe it was that day though. That's when we actually got the hard copy.
Did you receive the hard copy before you received the call about this incident?
Yes, Deputy Chin had the hard copy.
Okay. I have no further questions at this time.
Any follow-up?
No, Your Honor.
And they sat down, thank you. Is he released or?
Yes, we would rest.
Okay. Any evidence from the state? or from the defendant?
No, I don't have any evidence, Your Honor, no.
Okay. Any argument or anything you want to say?
Would like to say, Your Honor, just to make sure that everyone's clear, that we have 2 charges of felonious assault on a police officer, and that's either actually assaulting or attempting to assault a police officer with cause serious physical harm by means of a deadly weapon or dangerous ordinance. And in this case, the dangerous ordinance is the what looks to be an intentional effort to light the house on fire with the gas leak and the broken light bulbs. And they were put into that dangerous situation by being required to go there to aid the residents there, Mr. Thomas in particular, that was there. So that's the cause for those 2 charges. We also believe that the disrupting public services, that Mr. Thomas had to go, his own phone was broken. He had to leave and go across the street to find a phone to call the authorities. Vandalism, several different things that were done there. And we believe that he attempted to commit aggravated arson as well. And I think the circumstances, at least for probable cause, indicate that.
Mr. Steyer, do you have anything you want to argue?
Your Honor, I don't believe that the state has even necessarily reached the level of probable cause. I recognize that is a lower level of proof than what would be needed for a conviction. On the assault charges, there was no testimony that, no one gave testimony that Mr. Thomas actually caused any of these things to happen. There's some testimony that maybe he was the only one around that could have done it, but I don't think that anyone was competent to say whether anyone else was there in the time that he was otherwise alone in the home. Also, I think that the felonious assault, even at the lower level, does require knowingly cause physical harm to peace officers, and he had no reason, even if he did what he's accused of doing, he had no reason to believe the peace officers were going to be around. I don't think there's any way to link the alleged behavior to an attack on police officers who he had no reason to believe would be around. So I don't believe the state has met the burden on the felonious assault charges. I also, the disrupting public service, I'm not sure there's any indication that there was an intent to stop the phone from working. I just think there may have been other things going on there, but that would be my argument at this time. My bigger concern, Your Honor, is the bond in this matter being where it is. I think this is one, we've had testimony from both witnesses that there's a mental disorder going on at this time. The Deputy Bryce Adkins stated that he was talking out of his head, and Mr. John Thomas was adamant that he believed there's a mental health issue here. The bond right now is a simple cash or surety bond. I don't know if it wouldn't be, I say this sort of, I guess, when I give away the game, I'm anticipating that probable cause is going to be granted. I would like to know if the bond could be revised in some way that we could get him into some kind of mental health treatment, possibly with amended reads, that might be something the court would consider, the state would consider. I think that would be more use to him than sitting in the jail would be.
Mr. Thomas, I think, wants to speak. Mr. Hill,
there's always something that's bothered me.
Talk to Mr. Hill, and then we'll decide whether.
Okay, there's always something that's kind of bothers me about the arson thing. They say like the filaments and the light bulb.
Thomas, I'm not putting this on the record. Just talk with him, and then.
Oh, I'm talking too loud. Okay. day. And I'm the one that took the thing over, the document, and gave it to Officer Chino.
Do you think that there is a way, place that he can be put that you would be able to make sure, like a hospital or something?
He needs to be put somewhere. That's a lockdown facility if that's possible.
Well, there's not that many options is the
Yeah,
thing.
I
This
know.
gentleman he's of course Corey's father, and he wanted me to say that he's got maybe some different ideas on some of the evidence, but we still think it's very serious, the totality of this. He and your sister, don't you have? Or
His sister, my daughter.
Okay, so they went and got the mental health affidavit, got the warrant that day, or whatever that device is called. Yeah. So I don't know what that impact that might have on things, but we would like to see him someplace safe but constrained, whether it's in the jail or some sort of mental health facility, because it appears that he did that day could cause a lot of danger. It could cause a lot of problems for people.
Yeah, and unfortunately, we've decried this before on other cases, and I heard you just say to Mr. Thomas, there's not that many options, and they're not immediately accessible. I mean, we do have some facilities that are available for people with substance use and mental health, but under these circumstances, I'm not sure the local facility would be able to take him because it's too dangerous. I mean, they can't bring somebody that's exhibited this kind of behavior into their facility and put everyone at risk. I'm going to find there's probable cause to bond the case over. There may be needs to be some tweeting of this, but it's just a probable cause hearing. I think there is probable cause here. The common police court's going to be they have more options and can get people in to places that it's harder for me to get them in for treatment, but the problem is still time. Even from the common police level, from my understanding, there's a waiting period to get somebody into like Athens. And I've even been told, when I try to send them there, the state discourages our court sending them, so it's going to come from the common pleas faster than it will from this court. So I'm going to bond it over. I'm going to keep it at the same bond, and then you can approach. I mean, I don't know which judge will get, and who will be the lawyer. I mean, there's still a lot of unknowns here, but something needs to be done. He needs, just from the testimony and evidence here and from my past experiences, he needs some sort of mental health treatment. So Athens is probably the most logical place, but that's going to have to come from common pleas.
Right.
So case is bound over to the grand jury. Bond remains at $25,000, cash assured.
Do you mind if I talk to them? Okay, thank you. I'm going back. Yeah. Me? Yeah. Both of you. Mostly me.
Luke,
Yeah.
this first.
I can't see it.
Hey, are they recoming that Gary Casillas?
I wanted to show them the things. It's a salary person. I'm with the tricky attorney. So I can't negotiate anything until we work.
That's too bad.
I know, I'm gonna go give them my card, phone number, but we tell them the same thing. It gives them.
These notes are going with.
State of Ohio versus recall Cheyenne Meisner, TRD 143404 and TRD 143124.
Okay, were you here earlier and left, or what happened?
No, I've been here since 9:30. I guess I was sitting out there and didn't hear my name.
Okay, because you were called and we couldn't
Yes, I
find you, so
apologize.
I actually issued a warrant because I was told, well, she was here earlier, we don't know where she is now. So the penalty is you have to sit here all day, like I did, and listen to all these cases.
I've watched every one of them.
Okay, so let's see here. It looks like you may be finished. You paid your fines, it looks like, and I think your community service. So did you get arrested on this, or you just decided to clear it up?
No, I guess I just come in to clear it up, to pay it off, just to get it off out of the way.
That's one. Couldn't figure out if you got arrested and there was a bond that I didn't see, you didn't have to post a bond, you just came in on your own?
Yeah.
Okay, you are completed, your cases are completed, you do not have any other review dates, so you're free to go.
Thank you.
You're welcome. All right, let me just tell you this, Mr. Hargis, if you don't do a urine screen, you're gonna go to jail.
Sir?
You're gonna go to jail if you don't do the urine screen.
If you don't pee, you're going to go to jail.
You a wild card piece or?
Okay, I wasn't born yesterday, so. You got a few more minutes. Go with Mr. Major. You don't do it, you're going to Ironton.
State of Ohio recalls Alexis Smith.
Okay. This is a conviction from 2020, and you were out of pocket for 5 years, almost 5 years. Right? And then, did you go to OVP on your own, or how did you get to OVP? So that's a plus on your side, that you did it on your own. You've exhibited today some rather, I would call entitled behavior. You're trying to explain the unexplainable, trying to deny, and then you get on the stand, here we got 10 people doing a hearing, we're all tied up listening to you, and you admit you were disruptive. Why do you force us into that? Got an explanation for that? Okay, well, you got a jail sentence back in June of 2020. You probably should have got some jail time anyway, so you know what? I'm giving you a day in jail. 24 hours for your behavior out of the 20 days that I suspended. Do you still want her?
Yes, sir.
Can you pick her up from the jail tomorrow?
Yes,
Somebody
sir.
have her picked up?
Yes,
She can
sir.
be released at 2 o'clock tomorrow.
Yes,
Go
sir.
back to Southern Hope, but she's gonna be at the jail till then. And then your next review hearing, we'll keep May 27th, that's what your review hearing was, so. No more disruptions, no more entitled behavior, no more gabapentin. You don't need gabapentin. The guy who teaches, Dr. Davies, who teaches addiction medicine at Marshall, tells me, people that are taking Suboxone try to get gabapentin because they can get high, the combination of those two things. And you can Google it on your phone. You're not supposed to be taking those together. And I'm going to talk to Brianna about that. OVP should not be prescribing gabapentin to people that are on buprenorphine or Suboxone. Okay, go to the jail for a day. And then mind your P's and Q's and do what you're supposed to do from now on.
Yeah, you told me
Thank you, Your Honor.
You're welcome.
I'll make sure somebody's here to pick her up tomorrow at 2 o'clock.
2 o'clock
After
tomorrow.
2 o'clock, okay.
Does that excuse me, Judge?
Yes.
Thank you. Have a good weekend.
You too. Okay, the only thing we've got is Mr. Hargis. I told him to pee about 2 hours ago, and he says he still can't, so we're gonna see, we'll wait a little bit longer. If he doesn't, he's going to jail with Ms. Smith.
We just attempted, Your Honor, and he said he cannot keep.
Okay, I'll send you to the weekend in jail. Go with this guy up here. Your next hearing,
Right up there, deputy, right up there.
I'll set your, what did you say in June you couldn't do?
June 2nd and 9th.
Okay, June the 13th, Mr. Hargis, is your next hearing. June 13th.
Mr. Major?
June 13th.
I'll give you that, yes, I'll give that.
Yeah. Court's adjourned.
All right, thanks.
You said I was going to keep on the right now.
Well, yeah, I got it, but people drink enough water and people